Any mention?
May it please your Lordship. Lordship, I beg to mention item number 31. The conducting counsel, Mr. D. 31, Lordship. The conducting counsel, Mr. D. Sharma, is from Guwahati, and the third phase of the Lok Sabha elections is scheduled today.
So you are here. Guwahati lawyer, no excuse.
My lord, here, Lordship, on the last occasion, I was directed to produce the record as per the department whose name is reflected as nominee. I have already have the copy of the record, my lord.
Who's name reflected as nominee?
My lord, the son, my lord.
Not the petitioner.
The petitioner was before, my lord. Later on, it was changed to the son.
You've heard what the counsel said?
I have given the copy to the court master also, my lord, for Lordship's reference.
Okay, 2 weeks, yes.
You
convey that to your arguing counsel.
Yes, yes, madam.
Yes.
Please, Lordship. Lordship, I beg to mention item 25 and 27 for the petitioner. Item 25, Lordship.
25.
Lordship, 25 and 27.
25 is Uttara Sangma.
Uttara Sangma.
No objection, Your Lordship.
For 2 weeks, Lordship.
2 weeks, yes. 27?
27, Urmila Devi, my lord. Ms. Sham is there on the screen.
Yes. 27. No objection? 2 weeks, yes.
Obliged, Lordship.
Okay, 2 weeks, yes. Yes.
Please, Lordship. Lordship, I beg to mention item number 22, Lordship. Lordship, may kindly have this matter after 2 weeks, Lordship.
Who's
Taking
other
the
side?
consent from the other side.
As for the respondent number 5,
No urgency?
Lordship.
Ready to matter. 1 week, okay. Yes.
Lordship, similar prayer for item number 30, Lordship. 30.
Where's Mr. Riso?
Lordship, he's in the other court, Lordship. There's some part of matter, Lordship.
2 weeks, yes.
No objection.
Deeply obliged, Lordship.
Yeah, please, Your Lordship. I beg to mention item number 26.
George Amlanong.
Judge, I'm
You're for whom?
for respondent number 2, Your Lordship.
No objection, Your Lordship.
2 weeks, okay. Yes.
Highly obliged.
Yes.
Daily list, item number 1.
May I please, Your Lordship. Your Lordship, Counsel, Mr. Aston, he's on leg before division bench. So if the matter may take up after some time.
Sometimes.
Supplementary list, item number 1.
Throw Islamo. What is this?
Wait, please, Your Lordship. Lordship, we are challenging the order passed by the learned judge of District Council Court Joy, wherein she allowed the application of the respondent for leading additional evidence in an appellate stage, my lord. My lord, the brief background in this case that this
What
is
is wrong with letting them adduce additional evidence is necessary for the purposes of the trial?
My lord, because in this case, the trial court, they have framed 14 issues. So, in the appeal petition that they have filed, the respondent
Who filed the appeal petition?
Yeah, by the respondent. The respondent basically
already decreed against them.
No, actually, yes, my lord, the suit was dismissed. They were the plaintiff in the original suit.
Okay.
Yes. So in that original suit, my lord, my lord, that's what, my lord. It is beyond logic that now they are filing this application seeking to lead additional evidence with regard to this issue. Not only this, my lord, the material on the basis of which they are relying, they are praying for leading additional evidence, is on the basis of a map which was prepared by their own admission, my lord, which was prepared after the suit has been dismissed, after the judgment was rendered. This particular map, according to them, my lord, was on the basis of the survey carried out by the district council after the suit was
Well,
dismissed.
Like I mean, so.
Yes, yes.
What,
yes.
What's the finding of the council?
But there's nothing, my lord. They have not annexed any of the survey report. They have just annexed the map, and the map is very vague. It's only their statement saying that this woodland falls under Alakam Manso.
So the appellate court allowed the application for
Yes, my lord.
evidence.
Yes, my lord.
Remanded the matter back to the trial court.
Yes, my lord, for leading evidence on issue number 2. And this, my lord, this particular suit is from 1989, my lord.
89.
1989.
And when was it dismissed?
It was dismissed in 2011, my lord. Or 2017, my lord. So this is nothing but dragging the case, my lord.
Mr. Leonard, counsel for the petitioner, issue notice. Issue notice returnable in 3 weeks. Only one respondent steps to taken, but it said AD within 3 days. Yes. The council submits that the civil division application is directed against an order dated
20/2/2024. 20/2/2024.
24, whereby the judge, the council court, sitting in appeal, in judge council entitled civil appeal number so and so, has allowed an application filed by the appellant.
Yes, my lord.
For adducing additional evidence. Stop. It is submitted by the council that the order is bad in law as much as the same, the prayer for the evidence does not concern the basic issues on which the appeal has been filed. So, do you have any interim prayer?
Yes, my lord, to stay this order because the
Is that is an interim dependency the revision application that has been order dated 22 to be stayed. As this matter requires consideration. Such, accordingly, there being a prime facie case for grant of interim orders is provided until the next date. The order dated 20 to 2024 shall remain stayed. And list also.
Item number 2.
Lordship, I'm praying if this matter can be taken at the bottom of the board, Lordship. So, Senior Advocate Mr. Paul is appearing.
Bottom of the?
Board, Lordship. Board, Lordship.
What's the matter about?
Lordship, this matter pertains to tender, Lordship. Regarding
Tender?
Lordship, supply of MRI machine in Civil Hospital, Tura, Lordship.
That has already been awarded, my lord. Notice has to go and then we'll file reply.
It's already been installed.
That is as per page 52, their own writ petition, my
My
lord.
Lord, kindly have it at the bottom of the board.
Let us see.
Page 52, at 53, my lord. Paragraph 5. Paragraph 5, my lord. That on the contrary, we have been informed orally by sources in the department the tender has already been awarded to so and so, despite the being.
I mean, your bid was approved.
My lord, by the tender committee, my lord. My
Your
lord.
lordship,
It
only
was
one
it was,
thing,
my lord.
because what
We'll
if
hear it after some time.
we will.
Yes.
Item number 3.
There's also some tender matter, my lord, which came up yesterday. Sorry, my lord.
Yes, only for what is the matter about?
Lordship, this, my lord, was a tender which was floated for the purpose of.
Why did your junior counsel ask for 2 weeks' time?
Lordship, actually, there's some instruction that there is some scope of settlement. That is what. But
No, 2 weeks' time is necessary for what?
for
That's why I
obtaining the
listed that
instruction,
today.
my lord,
Is it
because
based
this
with
company is located
publicity?
company is located at Uttar Pradesh, my lord, Bareilly. So they have given some instruction that maybe there is a scope of settlement. So I'm not.
With whom? Who is against?
This is
whom
regarding
the contract?
MEPDCL, my lord.
Okay. Right then, Mr. S. Dev says that mail out 1 week's time to obtain instructions. 1 week or 2 weeks?
2 weeks. 2 weeks. We'll take positive
2 weeks' time
instructions.
to instructions list thereafter and so on. So.
Not sure. Obliged, Lordship.
Daily list, item number 2.
Lordship, the conducting counsel Y Pallavi is on her legs. So if this matter between
Who's the counsel?
Y Pallavi. Y Pallavi.
She's on legs where?
She has she's having some matter in other courts.
Which court?
The Delhi High Court. So she will be appearing through VC. If this matter be taken up at the end of the board, Lordship. At the end of the board.
Everything's at the end of the board. Are you still interested in the matter?
My lord, because the matter is almost over, she has made her submissions. I have given my reply. She sought some time, quite some time back, to give some.
She sought time on 19th March to present the matter physically the next day.
Yes, so matter was heard by my lord. She was online. She made her submissions. I've given my reply. She sought some time to give a rejoinder reply. I'm not sure on what exactly, but if she wants to appear today, maybe lordship can give her the kindness.
We can't extend this kind of courtesy unnecessarily because this is an election petition.
Yes, my lord.
Are you interested or you're
I'm very interested. I'm the plaintiff, my lord.
No, exactly. Many plaintiffs now it's become routine. They are filing adjournment petition.
Not this one.
If you take a call on that as for election law, then you can't just file election adjournments. And for withdrawal also, it's a different cup of tea.
Lordship, the records will show I've never sought an adjournment, my lord. Not once.
Never?
Not once.
If it's not ready in half an hour, you put an application for adjournment. Yes.
Obliged.
Item number 3.
Exchange of pleadings are completed, my lord, in this matter. So let it come for hearing, my lord, in the normal course.
What's the matter about?
My lord, this is a matter where I'm challenging the recalibration of the scheduled caste list and the scheduled tribe list, clubbing together and thereby drawing a merit list. Initially, I belong to the other ST tribes of Meghalaya. So I stood in the first ranking, my lord. Accordingly, I was given the job. Thereafter, somebody challenged in the challenged the select list, my lord. Then the recalibration happened. Recalibration happened, and the 5% of the scheduled tribe and the scheduled caste list were clubbed together, my lord. Clubbed together, and so that is the issue, my lord. Whether that's possible or not.
What is MPSC?
No, my lord, private respondent, my lord.
Where's the state?
Our colony was hearing lordship.
Under party submitted pleadings complete, only is a matter for hearing so and so. Yes.
Item number 4 are connected.
Yes. 4?
This is connected matter, my lord. 4 also, same order.
Yes, together with so and so for hearing.
5.
Yes.
Lordship, we have received the affidavit filed by respondent number 5.
I'm respondent number 5. I filed my affidavits.
1 to 4.
Lordship, we have already filed.
What do you want today?
We will file a rejoinder, Your Lordship.
Last time nobody appeared. Yes. So Mr. So-and-so prays for about
2 weeks' time, Lordship.
File that point number 5. 5.
Yes, sir.
Yes, so-and-so.
6.
Your Lordship will have to seek instruction from the petitioner whether we'll file our rejoinder or not. So kindly 3 weeks' time may be given, Your Lordship.
Yes, sir. 2 weeks' time is granted as separate to the petitioner to seek instructions whether to file rejoinder, if any. Yes. You file in 2 weeks. If not, then we'll post it for hearing after 2 weeks.
Yes, Your Lordship.
7.
Obliged, Your Lordship.
Lordship, rejoinder is almost ready, Lordship. Lordship, kindly grant us 1 week's time, Lordship, to file the rejoinder, Lordship.
1 week?
Lordship.
1 week's time, for the time is separate, now for rejoinder.
Highly obliged.
8.
Lordship, praying for more time to file affidavit on behalf of Mr. Sinkon.
Lordship, after motion, this is the sixth time they are seeking.
Sixth time?
Yeah.
What's the matter about?
Your Lordship, here the petitioner regular transfer has stopped by the respondent authorities for the second time without any justification and reason.
Regular transfer stopped?
Stop.
You appeal for whom?
Private respondent.
Well, suppose this matter. Do you have any records, any instructions with you?
It's
Who's appearing?
Mr. Sinkon.
Where you go to the office and get instructions ever received. You can't let this matter be this. As you inform him to appear.
2 weeks, Lordship, I'll file my affidavit.
2 weeks?
Yes, Lordship, I'll file my affidavit also. In time.
This is matter on. This is matter. Today is Tuesday. On Friday, be ready for disposal.
Lordship. Much obliged.
Yes.
Item number 9.
Routine transfer, you can't keep it pending for. When was the matter filed? Since last year. It's absurd. Yes.
Here, my lord, affidavits are awaited.
Lordship, I pay for some more time, Lordship, to file affidavit.
Here I'm from the private respondent, 6 Lordship. Similar
You already filed?
No, Lordship.
2 weeks time is paid for the time allowed to the response file affidavit.
Obliged.
10.
It is, Lordship. Lordship, on the earlier date, Lordship, I had to pray that your Lordship may dispose of the matter with the direction to dispose of the representation, Lordship.
Your Lordship, actually we have received the mediation notice last time, so we want to wait for the outcome which will be
Mediation
held.
notice?
Mediation, sir.
For
Your
this
Lordship.
matter?
Mediation. Promotion.
Lordship, I'm not aware about the mediation, but then there's a representation which is pending.
No, I mean this mediation notice from whom? Let's
I
see that.
I'm sorry, Your Lordship, it's not with me right now.
Is it this matter only? Is not reflected in the order sheet? Is not reflected in the order sheet that has been sent for mediation?
I
Is
was
it correct?
instructed.
Ms. Pradhan, is it correct? It's been sent for mediation?
Lordship, I'm not aware about this.
Lordship, I'm not aware about this mediation notice.
Service matter?
Your Lordship, may kindly be, take this matter after some time. I'll just
You just
seek instruction.
find out, yes. After some time.
11.
When there's other matters, when you allow for hearing, only go one for orders. How to see but this for hearing, only one for orders. No one is for orders. After orders. This is matter. Yes.
Twelve.
Lordship, this is a matter of the managing committee. Here, the school managing committee, the outgoing managing committee.
What was it for today?
Lordship, we have filed a petition for impleadment. Pleadings are complete in that case. It's for Lordship's consideration. That impleadment petition.
This is the case, Lordship. If
Since I am the petitioner, my Lord, can I start?
We have an objection. If the matter is heard, then I can explain. Because government has filed an affidavit in this case.
What do you say in affidavit?
Government says the managing committee should be constituted in accordance with the rules and laws. The rule says that only the outgoing managing committee 3 months before is to submit the proposals to the municipal schools along with elections held, teacher representative, guardian representative, donor members elections. In this case, we have submitted. Then the proposal which is submitted to the district education officer is the authority who has to give approval. District education officers has forwarded these to the directors. They found that the proposal submitted is complete, just to give the authority, convey the authority for the approval of the. In the meantime, Mr. Jindal's client, claiming to be Marwari Panchayat, saying that I am the sponsoring body, property belongs to me. That's what I am also entitled to submit the proposals. The government examined the proposal of the Marwari Panchayat also in the affidavit, government affidavit. Government affidavit says the proposal submitted by the Marwari Panchayat is incomplete.
Where is that one?
It's a government affidavit, page 12. The letter.
Lordship, in this miscase, I am the petitioner. If I'm allowed to start, maybe.
Let us see. See whether you.
Because here, because he wants his right and title to be decided in the writ petition which I file. The law says if you want to declare yourself as a sponsoring body, if you want to decide your right or interest, they have to go to civil court. Section 9 CPC said they can get the right established before civil court. But the government says, about my proposal submitted, government did not say anything. Government said only difficulty that because we received one proposal from the Marwari Panchayat, we could not take a decisions. But the proposal submitted by them is incomplete.
What's this pre-type plan?
Pre-type plan? Because they have to submit.
Where is that? Let's see that.
Pre-type plan is here, Lordship.
In?
If I Annexure 344, my writ petitions. This is a pre-type plan. So we have to President, Secretary.
Writ petition.
Writ petition.
Where is that page?
Page 44. You say here it is to type in accordance to that. If a proposal is to be submitted, the first will be President, Secretary, Joint Secretary. This is important is teachers' representative. It needs to be elected in the elections of the teachers. 2 teacher representatives. Then guardian representative, 2 guardian representatives.
The per type plan, where's the per type plan?
This
format.
The format should be in accordance with this only. Teachers
the common affidavit is said that the proposal submitted by this
incomplete.
The persons, I mean the body seeking to increase incomplete.
Because the
per type plan. What's the per type plan?
Because the teacher election was not held, donor members election was not held in their proposal, and the guardians also not held. But the proposal which I submitted, because the law says Rule 5 of Meghalaya Assam Education Act says only the outgoing managing committee has to intimate to the district education officer 3 months ahead. So we have submitted the proposal 3 months ahead, and what we submitted is also enclosed with the writ petitions. Annexure 1.
Now Annexure 321 is already over.
No, that is just to show that last managing committee.
Okay, this is.
But that last managing committee expired. Okay. Now Annexure 1. Annexure 1 is the proposal submitted by us.
Let us see.
Is a very complete proposal submitted. Proposal for granting approval to one constituted managing committee of this is a line. Then we have shown the President, Secretary, Joint Secretary, teachers, guardian, donors. Now election we have enclosed the minutes of the meeting also along with this. And the resolution was passed by the managing. The entire.
They have not approved your managing committee just because there has been an objection.
They have not approved because I have submitted to the competent authority, district education officers, and district education officer what he done, Lordship.
Mr. Jindal, what is your case then? If you can't even submit a proposal that can be taken into consideration, that means you're out.
My lord, I'll just take less than 5 minutes just to convince this honourable court as to why I am required.
That if the proposal has been sent by them and if as per the affidavit, if it says that your proposal is incomplete, is not as per type plan, then that means.
I'll address that. I'll address that.
You could not comply with the requirements. That means that you're not the competent body to reconsider managing committee.
I'll address that. I'll address that. Yeah, I'll take less than 5 minutes, my lord. Since it's my petition, like I had mentioned, Lordship, there are 2 reasons why I am trying to convince this honourable court that I am a required party, a necessary or a proper party in these proceedings, my lord. Lordship, just to draw attention of this Honorable Court to the petition which I have filed. I have filed a petition purely under Order 1, Rule 10, Sub Rule 2, my lord. That is for impleadment. So the only question today before this Honorable Court...
No, this court, it's not a question, only question today. Just want to know who you are and why.
Absolutely.
If you're basing your claim on a certain, like, cogent and, tangible kind of, substance, that means why couldn't you give a proposal that is acceptable?
My lord, to answer Lordship's question as to who am I,
Yes.
Lordship may kindly look at the petition which I have filed, the Miss Case 24. Miss Case 24, my lord. This is my Order 1, Rule 10 petition for impleadment. Annexure B of the petition, my lord. That's page 11. I am a society, my lord. I am a society, and this, my lord, is my memorandum. If I can draw Lordship's attention to the contents of the memorandum, specifically page 13, 1-3.
Yes.
The objects, my lord. I'll read, my lord. A. Social institutions. The Marwari Panchayat Shillong have instituted several socially relevant institutions like 1, 2, number 3, R.B. Anup Chand Hindi High School, Keating Road, Shillong. This is the school which is the subject matter of these proceedings. So I have established this school. I am the sponsor of the school. Number 1, my lord. Number 2, if Lordship looks at Annexure C, page 17, 1-7.
Yes.
This is a lease agreement in my name. It is under this lease agreement, the land covered by this lease agreement on which the school stands. Number 2, my lord. Number 3, my lord, if Lordship goes on, page 24, Annexure D1, D.
Yes.
This is a resolution, if I'm allowed to read the first line, my lord. Resolved unanimously that the names of the following persons be and are hereby selected for being proposed in their respective posts to the concerned officials of the Education Department, Government of Meghalaya, for induction into the impending reconstituted managing committee of RBA so-and-so school, of which Sri Marwari Panchayat Shillong is the sponsoring body. Names are there. This is a resolution we had passed. Subsequently, page 25,
yes.
we had, it contains the same names, the names of the proposed office bearers. This, my lord, was forwarded at page 26 to the government, to the state. Reconstitution.
No, but were you there in the old managing committee at all?
No, my lord, I was not
Then that is what the court wants to know. That what is your, why at this stage now you've come, now you got to establish your case right from the bottom up, Mr. Jindal. Because like if what is correct, if their banning committee have been approved all along, then it's at this stage, you're trying to, put a foot in the door. So like that is what has to be very.
Lordship will kindly appreciate this question which Lordship has raised is a pertinent question. This question is more properly the subject matter of the writ petition, my lord. That is, as and when and if I am allowed to participate in the writ petition, I am on the question that Lordship had initially raised, that is my locus or my right to participate in these proceedings. The application...
But has this matter not been decided before? You've taken a decision.
It's already decided, Lordship.
Lordship, if I can just finish, I'll just take a minute. More. Now, Lordship, that is as far as my petition is concerned, the documents on which I am relying on. The pleadings in this case from the writ petitioner and from the government would be more than enough reason for me to be impleaded. If I can explain, the case of the writ petitioner, my lord, is a very simple case. They had forwarded a proposal to the government containing proposed names.
They are an outgoing managing committee also.
Yes, they had. So their cases that they had.
As per the rules, they have sent it. Yes.
They have forwarded a proposal. According to them, the government has not acted on it. The government has sat on it. If I'm allowed to just sum up their case, this is there in the writ petition synopsis itself. If Lordship allows me, if Lordship kindly looks at the synopsis, it's a 2-line synopsis, my lord. The outgoing managing committee, whose tenure is likely to expire on so-and-so, submitted a proposal via letter dated so-and-so to the respondent number 2 for granting approval to the reconstituted managing committee of so-and-so school. Till date, no approval has been granted and no reason whatsoever has been assigned till date. Hence, the petitioner, having no option, has approached this Honourable Court in the interests of justice. So, the prayers which they have included in the writ petition are on those lines. They are seeking a direction from this Honourable Court for the state to be directed to approve their list, my lord. Now, the response of the government may kindly be looked at in the affidavit which they have filed in the main writ petition.
Yes.
If I'm allowed to take lordship to para 6 first.
Yes.
Now, para 6, my lord, I will not read the entire paragraph, but the annexures at the end of para 6 may be looked at. Government has referred to my representation, my resolution, etc. So they are seized of my representation, my documents, my letters, my lord. Para 7, if I'm allowed to read, my lord. Para 7. That with regard to the averments made at paragraphs 9 to 14 of the writ petition, the answering deponent reiterates what has already been stated in paragraphs 4, 5, and 6 of this affidavit in opposition. Moreover, the answering deponent vehemently denies that the actions of the state respondent is illegal, arbitrary, and malafide, and also denies having given any assurance of an approval to the petitioner. It is pertinent to mention herein that due to the claims and counterclaims between two parties in the constitution of the managing committee of Rai Bahadur so-and-so school, the matter pertaining to the approval of the same is pending.
Now, just one thing.
Yes.
In earlier occasion, when was the school established?
I have to take instructions. It's been some
now,
time.
1 second, Mr. Kurji. When is it established? Now, was this Marori Panchayat committee ever part of sponsoring body
Yes,
at a relevant point of
Yes,
time,
ma'am.
or just in the
Yes, ma'am.
near past?
No, my specific instruction is that, for example, in 2005, the body proposed by the sponsoring body, by us, by the Panchayat, was approved. So there are precedents.
That means you mean to say that this is just a fight between the... Now, who's the sponsoring body now?
Initially, what used to happen is, what had happened is, Mr. Qureshi's clients, members of that group, were part of the sponsoring body also. So sponsoring body, in its wisdom, thought it not necessary for a few years in between to extend any proposals to the government for reconstitution. It used to be the managing committee. So now, ground reality has changed. Now there is a new set of people in the sponsoring body.
Clash between these two groups.
It comes down to that, my lord. It comes down to that. But at the end of the day,
expense of the students.
But no, at the end of the day, at the end of the day, the limited question before my lord today is whether I am required.
No, it's not that. It's just a question of trying to understand the matter. Why for one school is that there's so much. Why? What's so important? It's just
It may just be a school, but I believe
not just a school. I mean, there's a school. It is an important institution. But why should two entities? I mean, like two groups fight over it? That is what is behind it.
Lordship, without instructions, I'm making a submission that this it's an institution, not just a school, but it's an institution that is a pillar of Marwari society in Shillong. So that being the case, my lord, it is important that things happen according to rules, that things are done according to rules.
And you're not part of the Panchayat committee?
No.
You're not, yes or no?
No, madam. No.
Some of the members are there. That is, if I start with that one, because by ignoring those members without intimation, anything, they have taken a decision of their own. That is not the, because if I go there, we will find many persons who are there.
Okay, we'll implead them.
We'll
impleed them. We'll impleed them. We'll impleed them because doesn't matter. Doesn't mean that there may not any case. We'll impleed them. We'll hear the matter.
My humble submission, Lordship.
Yes.
Impleadment, if it is impleaded, the system will change. But what is my submission that the writ petition as well as the implementation be taken up together.
Because I'm also impleading them.
No, it is maybe taken up together. Why is not impleaded, Lordship? The question of impleadment is very important. The necessary party, the proper party.
Why will implead them? Why will implead them? Mr.
If I can humbly suggest, my lord.
It's all right, Mr. General.
Yes.
It's why? Because it's on the basis of the affidavit of the government. You understand?
No,
that's why you understand as to without looking into your rival claims and contention.
No, Lordship, I have submitted my proposal in accordance with the rules, and the moreover
fine, that will hear the matter.
That is the.
We'll hear the matter. See, the same objections they raised now, they raised in the immediate petition. So we'll hear it. Yeah, miss case number 24 of...
Lordship, on the implementation petition, I have filed my objections.
No, we've heard you, Mr. Qureshi.
I have objection. The first objection...
Objections are noted.
Objection.
The notice
Objection.
that you are the real sponsoring body. You have submitted your reconstitution proposal as per the rules. We have come to the court for for approval, which has been done. And the reason for the not approving it as reflected by the affidavit is that there is a counterclaim which has to be resolved. And so we resolve by this court whether they have a right or not.
For that reason,
It's settle a matter once and for all.
Absolutely.
The affidavit which I filed against the imprisoned person, the objection we filed. The first objection is that they were nowhere in the school before. Only in the year 2005,
yes,
the Marwari Panchayat made some claim, and single bench has decided.
Where's that?
You see, here,
nobody.
Lordship, if I can,
Nobody,
if I can make a small suggestion, my lord.
One second.
We're
not linked in the.
I may be impleaded. The question of my locus may be kept open, my lord.
No locus.
Where's the judgment? You've supplied the court.
Yes. The judgment, the first judgment, which a single bench decided, is page 22 of my affidavit in opposition filed against the petition for impleadment.
Page?
Because this case already settled, decided already.
Okay. If it's decided, then fine. Where is that?
Page WPC number 341, 2002. Here the page 22 here. So this is the judgment whereby the single judge held the Marwari Panchayat is a minority institution, of this Hindi high school is a minority institution, so that they are entitled.
Where is this? This number 20, page 22.
Yes.
Yes.
32. He said, 33 he said, it is submitted that the London Council for the Parties, after the terms of the earlier managing committee has expired, the school has been managing and run by the inspector school. No managing committee has been constituted to date. From the letter dated Mr. School to the respondent 2, Director and Education, it is seen that proposal of for the managing committee was already been made by the respondent 3, but the managing committee would not be constituted due to pendency of the writ petition. The respondent number 2 and 3, Director and Inspectors are therefore allowed
Where are you
to.
reading from?
The judgment started from page 22 to page 33. So here the Lordship, here.
Which page reading from?
Suppose if I start reading regarding the minority declarations.
Where are you reading?
Page 32, para 10 to 15.
Yes.
Taking above view of the court in the case of Michael Lingdo, also interpretation of Article 31, the Constitution of India, by the Apex Court, in those cases referred to here and above, the court is of the opinion that school is a minority school. School is a minority school. The finding of the respondent 3 is for the school as stated in affidavit opposition that the school may be classified as a minority. It was sponsored by the Marwari Panchayat. And which
therefore found to be correct.
Now this is judgment. Now this is a judgment.
See, the finding of respondent number 3 inspector school is still affidavit that a school may classify minority as a sponsored is found to be correct. Okay, it's corrected. Yeah.
This is correct. Now this is the judgment of single bench was challenged in the writ appeal, and the writ appeal starts from page 34, annexures 1.
Okay.
This is this order. The findings of the single bench was set aside, and saying that the school is not the minority institution.
Where is that?
Judgment is quoted. Page 51, we wish to make it clear, bottom, we should not, by producing above observation of top court, be understood to say that school in this case has been established or administered just for the purpose of making the money, or private respondents also guilty of same wrongdoing. All that we wish to emphasize is that no evidence, not speak of sufficient evidence, has been properly adduced. No sufficient foundation has been laid by the private respondent to establish that school in question is a minority institution. Consequently, we have no alternative but to hold that the finding of the learned single judge that the school is a minority institution is perverse and based on no evidence. Under circumstances, it is difficult to sustain the impugned judgment. In view that we do not think it necessary to deal with the other contention raised by the learned counsel for both the parties. nor do we think it necessary to discuss the various discussion of the apex court and this court cited by both the parties.
But judgment also, with due respect, Mr. Qureshi, read para 13, which for the school question might have been established by the Mari committee through Mari Panchayat, or it might have been run by them till inception. However, unless there is evidence to show has been established, I'm sure for a benefit of the community, to automatically lead to conclusion. Out here, it's only what you're trying to show is that they have not established the case that they ever ran the school. That's your case.
That is a finding. Suppose if it is a minority institutions, they are saying that this is a minority institution established by the Marwari Panchayat, but it was not. Now, my writ petition is, Lordship, is just simple direction to the school to approve my committee. Suppose in case, if they want their right to be established in this writ petition, not permissible. Because CPC section 9 says, if they want to get their right decided, they have to approach the civil court, not by the writ court, because writ court cannot give declaration to the party, in favor of the party.
Here the whole matter will impede them, doesn't matter, at least.
Lordship,
see, we will take consideration all these judgments also. There are issues to be decided. It deserves consideration in view of the affidavit of the government. But Miss Case number 24.
But Lordship, the question of locus.
Miss Case of 24, 2024. This is an application by. Where's the application? By Sri Marwari Panchayat Shillong Society, stated to be registered under Meghalaya Society Registration Act. The ground set up for seeking impediment is that they are interested parties with regard to the reconstitution of the managing committee of what school is this?
Rai Bahadur.
Rai Bahadur.
Anup Chand Hindi Secondary School. Hindi Secondary School.
Hindi Secondary School is located at?
Keating Road, Shillong.
Located at Keating Road, Shillong. Stop. The application of impediment has been resisted by the writ petitioner on the grounds that the said society has no hand or has any locus to seek impediment, in as much as they're not involved in any way in the management of said institution, and the same has been run by the writ petitioners and other persons since its inception. There's been further submitted by Learned Counsel that the writ petition in question for this court only for directions, only for seeking directions for approval of the proposal submitted by the outgoing managing committee.
And it was forwarded to the...
For the constitution, yes. The state affidavit, however, has revealed that the non-approval of the managing committee, the non-approval of the managing committee as proposed by the writ petitioner and other persons is due to the fact that there is a counter-claim from the applicant, Marwari Panchayat Shillong. The same is recorded and reflected, the same is reflected in the letter dated 18 January 2024 under the hand of the District School Education Officer, East Khasi Hills. In this view, the matter, in order to settle the matter, it appears that the impediment of the applicant, namely, is necessary for proper adjudication of the matter. Accordingly, Ms. Case so-and-so is allowed, and the Marwari Panchayat Committee is included respondent number.
We will be 4. We will be 4.
Ms. Case accordingly stands disposed of. In the main case, in view of the order passed, Ms. Case so-and-so, registry to add applicant so-and-so as party respondent number 4. When you want to list the matter?
Because we want, but only the Lordship.
You don't require any affidavit.
Lordship, in this case,
Lordship, you're required to
the
file a
locus
small
of the.
Yes.
It is left open.
Yes,
Left open.
So yes. In the main case, it is made clear that the other points all remain open for
including the locus,
including the locus of the newly implemented respondents.
Interim order may be allowed to continue in the meantime.
Stop. In the meantime, interim order parcel shall continue until the next date.
My lord, we are required to file a small affidavit, my lord, in the main writ petition.
So Mr. S. Jindal is also, on behalf of the new impeachment permitted, seeks praise for allowed time to file an affidavit of opposition. Just after 2 weeks. 2 weeks.
Obliged.
We'll hear him, Mr. Qureshi. If they have anything, then we'll see. If not, then they'll be
settled law that
one nice.
Yes. No, but Lordship is a settled law that if suppose I want to get myself
clear. Now that's
just
what. No, let them say what they have to say. We'll settle the issue once.
Declaration they cannot take in my case.
They cannot, of course.
13.
Yes.
I'm praying for some more time.
Respondent yet to file affidavit.
Yes.
Respondents are yet to file their affidavit.
Dr. M. Sprayed for the how much time?
3 weeks time.
3 weeks time. Allowed to respond to file affidavit.
14.
Please, Your Lordship. Your Lordship, the petitioner here has filed a second RTI, Your Lordship. We have not received the reply from the respondent.
What is this?
But here there was some miscommunication. The interim order was not communicated to the department. And even prior to that, the offer of appointment was issued prior to the interim order was passed.
No, Your Lordship. The appointment order was issued under...
Appointment order, of course, was issued.
Yes.
But offer of appointment was already issued.
And as per order of this Honourable Court, Your Lordship, they have already received.
Otherwise, it will be difficult for the director. He has to appear personally.
My lord, in our affidavit, we stated, my lord,
we would not be happy to do, Dr. Mozika.
This has happened because I was not there, my lord. My associates were there and they never communicated.
And Your Lordship has already stated, they have already stated they have received notice, Your Lordship, on the day that this application was moved.
So what do you want time for now?
I want time, Your Lordship, because we have received the RTI, and based on those RTI, some information are incomplete.
Nobody submits that she may be allowed to file a small additional effort to bring certain materials, facts on record. Prayers allowed this for 1 week. Otherwise, it will be difficult.
1 week will not be suffice, Your Lordship. I don't think we'll receive the information unless they provide us within 1 week. Then we can do it, Your Lordship. If they can provide information to us within 1 week, then we can file, Your Lordship.
It is also understood that the respondent shall supply whatever required information to the writ petitioner.
The RTI is a different channel, my lord.
Through another channel. Through another channel. Although RTI application is pending.
15.
You make a letter with them or you ask for them.
All right. Highly obliged, Your Lordship.
Can't disobey orders of the court like this.
Well, we've tendered a policy. There was some miscommunication on my part also.
Then it's not your fault. They have to make it right. We are a council only. Yes.
Deeply.
Yes.
My lord, item 15, 16, 17, my lord, these are analogous matter. Prayer is for fresh election of VEC, my lord. My lord, our instruction is, my lord, item number 15 and 16 pertains to same VEC block, Halidiganj, my lord. Here, my lord, the reason for not conducting the election was there was an inquiry, my lord. There was a complaint regarding embezzlement of the funds, my lord. However, my lord, we are ready to go ahead because the inquiry report has already come. So we are praying if Lordship permits that we can go ahead for the election, item number 15 and 16. So far, 17, my lord, there's a different instruction, 17, my lord.
Basically, we come for election because...
With regard to 15 and 16.
Yes?
That is my submission, my lord, for 15 and 16. That is the prayer of the petition.
Yes, Mr. Sheikh. Regina Begum's is item number?
Regina is item number 15, my lord.
15, 16? Yes. What does the inquiry say?
My lord, the inquiry, some finding has been made, my lord. I have not been handed over the copy of the inquiry. The only thing is that there was an inquiry due to which they couldn't call for the election.
That is different.
We can record submissions.
We are ready to go for the first election, my lord.
Yes, by order dated 17/4/2024, this court had directed the learned senior government advocate to come forth with instructions as to why the elections, as for instructions, Tom. Today, Ms. Alconi, appearing for the respondents, has submitted that the reason for the delay in conducting the elections of the Princess Village, that is Holiday, Halliday, Ganj, BEC, under Holiday Ganj, GS Circle, West Garo Hills, was due to the fact that there was an inquiry which has since, regard to alleged embezzlement of funds, which has since been
An inquiry was constituted, my lord, completed.
Since been completed. So she submits that on instructions. She submits that on instructions. The respondents are ready to conduct elections at the earliest possible time. Right? Yes, are ready to conduct the elections. Next paragraph. Mr. S.A. Sheikh, with submission, praised that the matter will be closed, directing the response to hold elections within what time?
The block development officer, program officer.
Respondent number, you can lordship 3 and 4 lordship. Respondent 3 and 4.
Is deputy commissioner.
Hold elections within?
She can.
My lord, as per lordship direction, my lord, we are ready, my lord.
Within
It won't
2
be
months.
2 months, my lord.
2 months too long.
Too long lordship. Because it has part last year lordship.
Within 6 weeks.
My lord.
On the date of this order, yes. Next paragraph. Having heard the counsels for the parties and submission to learned government advocate especially, this matter is closed off. Is closed, directing the respondents number
3 and 4.
3 and 4 to conduct elections of the Holiday Ganj BEC within 6 weeks from the date of the order. Accordingly, it will proceed according to submitted petition stands closed and disposed of. And 16.
My lord, in 16, we have been informed that the VEC has already been constituted in the month of November.
Then?
This pertains to item number 17, my lord. 16 is same. 16 is same.
16 Holiday Ganj only.
Holiday Ganj only, my lord.
No, 16 is
Holiday Ganj.
Sakmal lordship. This is different place lordship.
It falls in the Holiday Ganj block, my
But
lord.
here
As per
same
this-
things. Inquiry was done same thing.
My lord, the inquiry was in Holiday Ganj, my lord.
Not in this case lordship.
Yes, with regard to this one, because under the Holiday Ganj.
It's under Holiday Ganj, as per my
GS Circle is under Holiday Ganj, but
Holiday
place is
Ganj.
different.
You only have to write that the reason given. To just read out.
My lord, the petitioner says Holiday Ganj only in her petition only.
Under GS Circle.
But then these are all under same. Yeah, same.
Hailakandi, Holiday Ganj. From Holiday Ganj to Hailakandi. Yes. In this matter, in the reasons for the delay, and this one you have to write Sakmal BEC. You're wrong. Under Holiday Ganj GS Circle. Not Holiday Ganj. Only on Holiday Ganj. Item 15. This one is Sakmal prayer. The reason for delay is that due to inquiries conducted in Holiday Ganj, under which Sakmal VEC falls under same circle.
No, my lord, that is Holiday Ganj is different VEC.
Then why do you write here under in your prayer?
GS falls under the GS Circle.
GS Circle.
GS
that's what I'm
Circle, yes,
saying,
lordship.
These are all
Because
under
that was not
Holiday
the.
Ganj.
Yes.
Then last one, 17. What was the problem with this other one?
My lord, the other one is Silkata, my lord. The area
Nila P. Begum. Nila P. Begum, yes.
in Silkata, my lord, our instruction says that VEC has already been constituted in the month of November 2023.
Then she can.
If lordship
Then why you
permits,
come with a frivolous player?
No, lordship,
Will
she can
impose
come.
cost?
No, lordship, we are not aware, lordship, because there was the election, in fact.
My lord, that
File affidavit.
She can file an affidavit,
Yes,
Lordship.
item 7, the MSR Kohli GA submits instructions that submits that as per instructions, elections to
Silkata
the
village
Silkata
at
VEC under Haliliganji circle had already been conducted in November 2023. She is directed to file affidavit to bring this fact on record. Just after 2 weeks.
Bye.
18.
You also for affidavit, madam. I'm praying for some more time. 3 weeks.
You're there at all. Number 18.
18, sir.
Sorry.
Yeah.
I'm praying for some more time, Your Lordship.
Why? What
I need
about?
to get the signature. I need to get the signature, Your Lordship.
Yes, you got affidavit from the government?
Yes, I hope.
You want to file a rejoinder?
I'll file a small rejoinder, Lordship.
What's the matter about?
Because this is for to regularize and to pay the pension. Because after working for 32 years, their pension is already under process, but now they are denying that she has not been regularized.
Miss Impiosa prays for further 1 week's time.
Yes, Lord.
Affidavit stopped. Affidavit of response 125 already on board.
Lordship.
Petitions permitted to file a rejoinder if required before the
Lordship.
next date.
Much blessed, Lordship.
Yes.
19.
I'm praying for some time.
Now come the right matter. Yes, sir. 3 weeks further time as prayed allowed. For affidavit. None appears for petitioner recorded.
Second call, supplementary list item number 2.
Please, Lordship. Lordship, may I have this at the end of the board?
End of the board?
Yes, Lordship. Lordship, the learned advocate general is on next before the learned advocate's court, Lordship.
Where's the petitioner? He's not here also. Yes. 2 minutes ago, election petition.
Daily list item number 1. Second call.
Your Lordship, my lord, I am yet to receive the instruction.
Then you reinstate him.
No, my lord, I have sent my lord, immediately, my lord, I have sent.
But then you can communicate over the telephone.
Lordship, I will not seek a long adjournment, very short adjournment. Let it come up on Monday, Lordship. My lord, without fail, I will take it personally, my lord, that I get the file.
It's against statutory. It's against
No,
statutory.
I understand your Lordship, because it is a statutory thing, my lord,
Whatever
it cannot be
might be,
correct.
whatever
But only
instruction
thing,
is
whether
done
they
for
have done
the
it or
purpose.
not, my lord, I have sent it. It is with establishment to your Lordships. Let it come up on Monday, my lord, I undertake your Lordships.
It's affecting. I'm out of job, Lordship. Under suspension. Since
Monday, my lord,
February,
without
Lordship.
fail, I am undertaking your Lordship.
Mr. SN submits prays that he may be allowed some accommodation and undertakes to produce the come instructions on Monday, the 13th. Yes, this is a matter on 13th. This is May, right? 13 May. Yes.
All right.
Yes.
Item number 2.
Where's Mr. Jindal?
Lordships, I am appearing for the applicant, Order 7 Rule 11.
Do you have anything else to say?
Your Lordships, I have to meet her.
You put an adjournment application, we'll give you a short date. You're somebody from the car, I can see.
Your Lordships, my sincere apologies. I was on my legs before the court, and due to some
You tell him to
unavoidable
put, you tell him to put
circumstances, I
an
could not be
application
present.
adjournment, we'll give you a short date, yes. Yes, we'll listen
Please,
on
Your
Monday,
Lordships.
yes. You put an application to adjournment, yes.
Please, Lordships, please, Lordships.
Observe that what? Let somebody play the car.
No further adjournments.
No. Ask him to some other, yes.
Your Lordships, however, I am willing to argue the matter because in whatever situation
Doesn't
I
matter,
am, but
Monday,
sincere
Monday,
apology.
be ready, yes.
Please, Your Lordships, I am grateful, Your Lordships.
Item number 10.
I seriously thought that he was submitting that put an order that somebody from inside the car.
We received notice for mediation.
So. Yes.
Well, in this case, I just got the instruction from our client that he received some kind of notice for mediation. So, well, if that is so, let him try.
What matters is contract?
No. This is my lord, with regard to my lord, what happened, your lordships. Here the writ petitioner and the private respondents. Private respondents, my lord, initially holding the post of inspector of schools. And we are assistant teachers, my lord. Initially, these were, my lord, in 90s we entered service. These were in the common cadre. Same salary, same interchangeable. Now, subsequently, what happened in 2010, when the rule has been framed, my lord, they have been separated. And so far, inspector of school are concerned, my lord, there was a provision for redesignating them, your lordship, on completion of area service. There is also a promotion. Now, our promotion was also due, my lord. Now, what happened, though these inspector of schools were junior to us, they were promoted ahead of us. Now,
mediation on what? Who will mediate?
That's what I don't know. Just I got the instruction. I could not look at the I think. Because our only limited prayer here is, my lord, at least in the seniority list in the.
Ask your juniors. Look at Allah.
Yes.
It is. Okay, then fine. We won't take it up. It's I submitted the matter is to come to look at on 11th. 11th, right? List the matter thereafter.
No right.
Hearing.
We should look at a different thing to do.
Hearing item 20. Hearing item 20.
Yes, Mr.
My lord, in this case,
it'll take a long time.
Some time, my lord, will
yes.
take case. My lord, in this case, we have challenged the notification dated 19 April 2023 for holding of election of Doloi, Ilakarembai, East Jaintia Hills District.
Who gave this document?
We filed at the time of, my lord, consideration of the interim prayer. We filed these compilations.
Okay.
There are some relevant judgments and relevant notifications are there.
Okay, yes.
Here, my lord, we have challenged the notification, my lord, dated 19 April 2023 for holding of election of Doloi, Ilakarimbai, East Jaintia Hills District. 19th April 2023, my lord. That is at page number 14, Annexure 1, and type copy is at the next page, my lord. That is Annexure 15, page number 15, my lord. This notification was pertaining to the holding of election of Doloi, Ilakarimbai, East Jaintia Hills District. My lord, the notification was challenged on two grounds, my lord.
Yes.
Firstly, because the notification did not include the eligible clan who are competent to contest the election, my lord. And the second point is, my lord, the notification was general in nature because it allowed anybody belonging to any religion, my lord, any faith, they can come and contest for the post of Doloi, my lord. My lord, here we are concerned about the post of Doloi. Now, the post, my lord, post of Doloi, my lord, it has to function, it has to perform both administrative as well as religious duties, my lord.
The Doloi of which?
Doloi of Ilakarimbai, my lord.
Oh, yes.
Yes. It has to perform, my lord, two sets of duties, my lord, that is administrative as well as religious duties. Now, if my lord will come to my petition, my lord, I'll read out from paragraph 2, my lord, page number 6. It is regarding that particular ilaka.
All have been served.
My lord.
Paragraph number?
Paragraph 2.
Yes.
Page number 6, my lord. That the Ilakarimbai is one of the oldest among the 12 Doloi of Jaintia, that the Senrise Ilakarimbai was established as a socio-religious cultural bodies with the aims and objective to preserve the rich culture, custom, heritage, religious rites and rituals which are the essential parts of the lives of the Jaintia belief and practice. It consists of 3 rais such as rais Rangad, rais Dingsin Room and rais Batao. The Rangad is one of the rais under the Ilaka Rimbai where large populations of the rais are following their indigenous faith, traditions, customs and culture. Some of the villages falling under the rais Rangad are Lumputhoy, Munnongtudu, Rimbai, Lumsken, Rangadhe. This rais has important rituals to be performed once a year and it is called as Knia Rinkau. And many other rituals are Knia Sindon Doloi, Knia Umrilin, Knia Umlinang, Knia Khada Rinkau. Paragraph 3, my lord. That the Doloi in the Ilaka Rimbai discharges both administrative as well as religious duties attached to its office. That to perform the Knia Rinkau rituals, Doloi is the main person as the head of the Ilaka to initiate the rituals, such as to convey the meeting among all the members of the rais and perform the rituals together with the lingdo of the rais. The Doloi has to participate during the Knia Rinkau rituals, such as the Sut Kashor, as the first step of the rituals, which is to be performed in presence of all other key members of the rais. Paragraph 4, my lord. That after the ritual is performed, it is followed by Kasad Niyam Paste Rinkau. That Kasad Niyam Paste Rinkau begins with 2 key persons of the rais, the Doloi and the Lingdo, and then it is followed by others called Sonyam, where members of the rais participates, including the mother and children of the rais. The Sat Paste is an important war dance of the Panar people. In this dance form, only the males takes part carrying their sword and shield, dancing to the beat of the war drums and the ghungrus. The Doloi leads the dance followed by the Lingdo and the remaining dancers. Now this is little bit, my lord, which I mentioned in my petition, and if my lord will come to the affidavit, my lord, which I have filed. Against respondent number 2, my lord.
Yes.
Here, my lord, in my affidavit at page number 34.
30?
34, my lord.
Yes.
My lord will come to paragraph 6.
1 second.
Yes, ma'am.
Page 34.
Yes.
Clan can be elected to Doloi.
The clan who can be elected in page number 34, paragraph 6, my lord. Down. Just below. Paste Rinkau at Rais Rangad. The Paste Rinkau is the most important religious ceremonies at Rais Rangad. This religious ceremony is done in devotion of Rinkau, Jotkiri and Rinkau Sindon to protect and shield all the clans from enemies, from the pain and suffering, from sickness and evils, and for peace and tranquility of the rais. This religious ceremony is done in the rais by the Doloi, the Lingdo and the elders of the clan. The Paste Rinkau is a ceremony with full devotions and sincerity by the believer of the indigenous faith under Saikrong Saikri. Duties of Doloi at Paste Rinkau at Rais Rangad. The Paste Rinkau shall commence by inviting all elders of the clan and the people within the rais by the Doloi and the Lingdo, and to deliberate and organize with regard to the religious and cultural ceremonies of Paste Rinkau. The religious ceremony first commences on the day of the Pinsin, and the Doloi shall bless all the ceremonial components items before handing to the Lingdo rais. On the day of Pinsin, after the ceremonial components items handover, the Lingdo rais shall put a turban on the Doloi before religious ceremonies is to be performed for the Rinkau Jotkiri and Rinkau Sindon at the house of the worship. After the ceremony, the Doloi and the Lingdo moves out of the house of worship, taking with them a sword and shield and a drum, and shall then 3 times swing towards Mu Pirtu. After religious ceremony is done at the house of worship, the Doloi and the Lingdo rais starts religious paste dance in front of Mu Pirtu. The Doloi shall have his shares of blessing of the religious components items on the big day of the religious ceremonies of Jotkiri and Sindon Doloi. The Doloi shall have his shares of blessing at the Knya Siar Smai on the final day of the religious ceremonies of Pasterinka. My lord, this is.
Now, who authored this one?
My lord, this
since on page 31, who's the author of this?
My lord, this has been
collected by whom?
This has been
appear in any book.
This is not by the book, my lord. This has been given by the petitioners, my lord, who are also the chairman of who is the first petitioner is the chairman of Sunrise Ilaka Rimba, indigenous. Now, my lord, this
so
is.
You mean to say that this is time immemorial?
My lord, these practices
has a very important function in this thing.
These practices have been continuing, my lord, from time immemorial. Now, these are as far as the religious part which a Doloi has to perform, along with the administrative functions, my lord. Now, is my petition. Now, if my lord has an act, 2015 Act, my lord.
It is in the compilation. By compilation.
Yes.
Now, my lord, this is the Act, the Jaintia Hills Autonomous District Establishment of Ilaka, Village and Election, Appointment, Power, Functions and Jurisdictions of Doloi, Sirdar and Wahesnong Act 2015.
Yes.
Now, if my lord will come to the preamble.
Yes.
The first paragraph of the preamble says, whereas the Ilakas are the existing traditional provinces of tribal administrations of the indigenous tribes of the Jaintia Hills and the state of Meghalaya.
Yes.
And the second paragraph, my lord, it says, whereas the Doloi/Sirdar is the traditional customary chief and principal functionary and head of the Ilaka.
Yes.
Doloi is, my lord, is the traditional customary chief and primary functionary and head of the Ilaka, my lord.
Yes.
My lord, section 2 of the said Act, my lord, it defines Doloi,
yes.
And also it says customary functionary, clause 2, subsection 3, my lord. Customary functionary means Lingdo, Pator, Sangot, Basan, or any other who are appointed as such by the Doloi, my lord, because Doloi is the head. And who is the Doloi, my lord? It says means a traditional customary chief.
Yes.
Subsection 20, my lord, of the section 2, it defines puja land.
No, this is common because they given puja land and other land where they derive the income sustenance from there.
It says means a revenue-free land held and cultivated by a Doloi, Sirdar or any customary functionaries, and the yield or income therefrom is utilized for meeting the expenses connected with religious performance.
And he has other one which is service land given to him for
service
rendered.
Yes. My lord, will now come to the affidavit filed by the district council, my lord.
Mr. New President District Council.
Yes.
That is respondent number 2.
Respondent number 2, my lord.
Okay, yes. Barcelona Bowman.
Yes. Now, my lord, will come to page number 8, paragraph 9. Paragraph 9, my lord.
Yes.
It says, my lord, that with regard to the averments and statement made in paragraph 10, 11, 12 and 13 of the repetition, the deponent denies the same and states that the notification dated so and so has been issued by following due process of law as laid down in section 4 of the Act 2015. It is reiterated herein that the customary practices in existence and prevailing in Rimba Ilaka has never been violated, in as much as in cases or situations where a Doloi who has been elected belonging to Niyamtrai denomination, it is the Doloi who shall perform the religious ceremony and rituals But in cases or situations where a doloi has been elected belonging to Christian denominations, it shall be the lingdo who shall perform the religious and rituals ceremonies so as the customary
Well,
practices.
cannot be Christian also, that means.
Yes, my lord, here.
Suppose Lingdo is a Christian also.
It cannot
Or he
be.
can't
My lord.
be.
It cannot be. My lord, those rituals has to be performed.
No, Lingdo cannot be a Christian.
No, my lord.
Yes.
It shall be lingdo who shall perform the religious and ritual ceremonies so as the customary practices is not disturbed, discontinued or broken down. As such, in view thereof, customary practices prevailing with regard to performance of religious ceremonies and rituals in the ilaka is still enforced and not disturbed or discontinued. Their contention is that, my lord, whenever any doloi is elected from Niyamtari faith, my lord, then doloi will perform those rituals. If a doloi is elected from other faith, my lord, then in that case, lingdo will perform. That is their stand, my lord.
What, when in this line of dolois, how many are from Niyamtari and how many have been Christian who have occupied office?
My lord will see in the same affidavit in my rejoinder, my lord, that my lord has already seen before.
Yes.
Number 2. In my rejoinder, my lord, there was an inquiry, my lord, in fact, which was conducted in the year 1971 when this similar situations came up. Till then, my lord, there was nobody who belonged to any other faith, my lord, than Niyamtari, my lord. There was an inquiry, my lord, in the year 1971 on the basis of a complaint, and my lord will come to page number 22 of my affidavit, my lord, against respondent number 2. Page number 22, my lord.
Yes.
It says, my lord, the paragraph I am reading, my lord, first paragraph. The first 3 are dolois during the Jaintia Raja's regime. The rest are dolois from British regime till the death of late doloi viz. Yengswer. All the dolois above are non-Christians excepting Yengswer, who has converted a few years before his death. Prior to that, my lord, all the dolois, my lord, they belong to indigenous faith, my lord, and because there was complaint, my lord, this inquiry was conducted. It was found that all the dolois, my lord, prior was.
This is dated?
This is.
The documents of which vintage?
This is 1971, if I am not wrong, my lord.
8 December 72 and 25th January 73.
Yes.
Read from the beginning. It's an interesting document.
Yes.
Old document.
I'll read, my lord.
As
many as 11 headmen and 3 lingdos of Rimbai Ilaka were examined and their evidence recorded and submitted as annexure from page number 1 to 17 below.
The records available of this, where does it come from?
This is from the district council, my lord, through RTA, my lord.
Is it available, Mr.
Will be.
The records of this inquiry? Very interesting.
I know, my lordship will ask this. It will come to this, I know very well. So far this 73 is concerned, my lord, this is very old documents.
That is what, they'll have a seal of...
And it will boil down to this, your lordship.
Should be available, my lord.
Now, my lord, we will have to, my lord.
Please get the records.
Yes, I will try, my lord. It's a very old.
I'll read, my lord. As many as 11 headmen and 3 lingdo of Rimbai Ilaka were examined and their evidences recorded and submitted as annexure from page number 1 to 17 below.
It's very important what were the... At that time was...
One admission is here, only thing, one admission is here. Even before independence, there was a Christian dollar. That admission
is
but
that is wrong.
You see, even during that time when in July also, it happened, there was an absolute, the whole system broke down because they couldn't complete the rituals and it put, the citizens to great difficulty as a thing. So because of some pujas which have to be very, sanctimonious in the sense that they had to perform by the law as ordained. So that's the thing. So that's why there was some resentment. That's the case also. Taking the constitution, the JCDC issued that notification also, which I was fortunate to be part of the litigation, was that only it's limited to those clans who are eligible and also should be a
indigenous,
non-Christian, whatever, indigenous Nyamtre. So that is why that was challenged on saying that doloi is a public office, and the Article 16 prohibits any classification or discrimination. But Supreme Court held that no, and certain of since they have both temporal, secular, and other duties.
No, I have seen that.
That has a big bearing. So and if he can establish that, you know, historically, now that is the correct, then we have
In
to.
fact, this case has been inspired by that Supreme Court judgment, it seems. But I'll distinguish your lordship. That is anyway.
Yes.
Summing up of the opinions and informations as recorded in the memorandum, the following facts transpires and corroborated by a majority
One
presence.
understand, second, why didn't come the writ petition?
My lord,
Proving your case after you filed the writ
my
petition.
lord, in the writ petition, my lord, we have challenged the notification, which was required was notification, my lord, we have enclosed.
Okay.
According to customs, only a person belonging to the following clans, Swer, Lingdo, and Nongtodu could be elected and contest for the post of Doloi in Rimba Ilaka. Only male adult who is a citizen of Ilaka who had attained the age of 20 years and above could be elected on the election of Doloi. Opinion differs as to whether a persons other than non-Christians, Niyam Snong or Niyam Rim, could also be elected Doloi. The majority, mostly Christians, on the one hand, claims that a Doloi is only an administrative head. He has nothing to do with religious performance, although as head of the Ilaka, he used to be visit and may also contribute to such expenses in connections with religious performance of the non-Christians residing within the Ilaka. They maintain that the Doloi has no religious obligations as far as customs are concerned. On the other hand, non-Christians, mostly residents of Rangat, Lumsken and Suchen village, claim that a Doloi was actually a functions. He is an administrative as well as religious head. It is contended that after his elections as a Doloi of the Ilaka, he would have to be coronated and confirmed as a religious head by a Lingdo of Rangat village. They also maintain that certain religious ceremony known as Di Tingkong would have to be performed, where his personal presence and participation is imperative, being an important functions and process of his coronation ceremonies. Besides these, there are also other religious ceremonies which are being performed till today by non-Christians. Thor, Rinkau, Jotkri, and Pertu, etc. In both ceremonies, these groups claim that personal participations and contributions of a Doloi is obligatory. According to the history, the following are the Doloi in Ilaka Rimbai in the past: U Riang Swer, U Du Nongtudu, U Mon Lingdo, U Riang Lingdo, U Prin Nongtudu, U Yang Swer. The first three are Dolois during the Jaintia Raja's regime. The rest are Dolois from British regime till the death of late Doloi Yang Swer. All the Dolois above are non-Christian excepting Yang Swer, who has converted a few years before his death. Therefore, it is claimed that irreparable loss and damages...
There's a typographical error here.
Yes, my lord.
That can be read down.
Yes. Therefore, it is claimed that irreparable loss and damages would be done to their religious sentiments. More so, it would tantamount to suppression of customs if a non-Christians would be allowed to be elected. It is also submitted for considerations of the executive committee if in a secular state, India, the constitutional and fundamental rights of the people of the Ilaka, which constitute a majority Christians, would be deprived of simply on the ground of their religion, also for upholding a customary practice recognized and upheld by a minority non-Christians. Now here, my lord, as far as the inquiry was concerned, inquiry has found out that all the previous Dolois were non-Christians, my lord. Now, my lord, what has happened? Even prior, my lord, similar situations came up till the year, my lord, 1971. The person, my lord, who is named here in the report, my lord...
State is a party here or no?
Yes, state is a party.
Yes.
Till the time, my lord, 1971, Yang Swer, my lord, he was the Doloi.
Elected when?
If exact date, my lord, I cannot say, but till the year 1971, my lord, because the objections was filed in the year 1971.
Where is that?
The objection is at page number 17 of this affidavit only.
Yang Swer was elected in 1926 up to his death 1971.
My
yes,
God.
1971, yes.
1926 up to 1971.
Yeah. He was
1926 till 1971.
He belonged to Niyamtre faith, my lord, but before his death, my lord, he was converted to Christianity, my lord.
Okay.
So therefore, my lord, people also had some grievances at my lord page number 17, if my lord will see.
Yes.
This objection is very important, my lord. The typed copy is at page number 19.
A translated copy. You mean?
Yes, sir. I'll just read this
Yes.
objection. This is the objection, my lord. It was filed in the year 1971. We, the undersigned for the Darbar Rangan and others, we request an appeal upon the subjects as stated below. As per the notifications of the Darbar Ilaka District Council, JD, Joai, it has been announced to the general public that elections of Doloi will be held in place of Yengswer, who died recently this year. In the Darbar Ilaka, we from the Rangad village, we have informed that whoever hold the post of Doloi has to perform his religious duty along with the Lingdo of Rangad, and he has to be from the indigenous faith. As per religious practices in the Ilaka Rimbai, Doloi is the head of the administrations and he is also the custodian of the religious practices. The Rangad village is the village that falls under Rimbai Ilaka. The religious practice paste has to be organized by the Lingdo and with the Doloi Ilaka Rimbai. These rituals begins with Perna, local wine, which has to be given by the Doloi Rimbai. In the rituals of paste, the Lingdo of Rangad village has to pin the flower, Solubon, in the turban of Doloi. The Solubon is collected and received from the outside of the Jaintia. Those were the religious practice of Doloi, Ilaka Rimbai, who has to perform the religious duties, and he must be from the indigenous faith only, non-Christians. And whoever converted to Christian faith, he shall not be allowed to be a candidate for the election of Doloi, Ilaka Rimbai. As mentioned above, it is true that we have practiced this since olden times until now. After being elected as a Doloi, if he converted to any other religion, it is against our religious practice within our Ilaka Rimbai, likewise in Ilaka Joai and other Ilaka. As Yangs were Doloi Rimbai, who have expired and whom we respected the most, he took part and participated in our religious rites till he hold the last year of his office due to illness and relinquish his indigenous faith without informing us, and we did not know how much it hurt our sentiments and it was against our custom. On the above noted reasons, we, for the purpose of preserving our customs and religious rites within our village and Ilaka, and we kindly request you to ensure and scrutinize the qualifications of the candidates before electing the Doloi of the candidate in Ilaka Rimbai, to announce whoever wanted to contest for the post of Doloi elections, Ilaka Rimbai, he shall belong to indigenous faith. A person who converted from indigenous faith to Christian faith shall not be qualified to contest for the post of Doloi. That the district councils should reject the claim of the Darbar Ilaka, where they have claimed that a Doloi does not have any religious duties. As for for your act of kindness, we, the Darbar Rangat, shall ever pray. So this is the objections, my lord, which was filed after the death of Yengswer, when they realized that the last Doloi, who belonged to the indigenous faith, my lord, just prior to his death, my lord, he has been converted to Christianity, my lord. Again, my lord, similar situations came up in the year 2014, my lord. My lord will come to page number 23. Another objections was filed, my lord. Page number 23, my lord.
Yes.
My affidavit. Here, my lord, it says, we the understand.
Annexure?
Annexure 3, my lord, page number 23. Same affidavit, my lord.
Yes. Yes.
Just read out, my lord. We, the undersigned below, bring to your office about the following facts regarding the above mentioned subjects for your kind considerations. That's our wide notifications dated so and so, number so and so. The office of the Deputy Secretary, Executive Committee and Returning Officer, Doloiship Election 2014, JHADC, is pleased to notify the election of Doloi of Ilaka Rimbai was scheduled to start from 13/6/2014 as per the program, when the draft electoral was published, and thereafter follows by the subsequent dates until the vote count on so and so date. That's how we are very happy to see over the step taken by the Office of the Deputy Secretary, Executive Committee and Returning Officer, Doloiship Election so and so, to conduct the election of the Doloi Ilaka Rimbai, which was the general expectations of everyone, to have the Doloi of the Ilaka as soon as possible after the then Udud Doloi late Batskhem Lingdo has expired. That, sir, contrary to the general expectations of the people, it is regret to state that the elections to the post of Doloi Ilaka Rimbai was not done as per the customary practices of the people of the Ilaka. It is to be noted here that the Doloi should belong to the indigenous faith who can perform administrative duty as well as religious rites and rituals for the people and the Ilaka as a whole. But this traditional practice of the Ilaka appeared to have been done away by the district council by allowing people from other faith to stand for election to the post of Doloi other than the Panar tribe of indigenous faith. It is regret to state that two previous Doloi, namely Riswer and ex-Doloi Ubatskam Lingdo, who have just expired, were Christians by faith, and we have no idea as to how the district council has allowed this to happen. That, sir, besides the above unwarranted incident, there are other incidents too, which the district council failed to take corrective steps to safeguard and preserve the culture, traditions and custom and uses of the Panar people and the Ilaka Rimbai in particular. It may be mentioned as per the notifications for an election to the post of Doloi Ilaka Rimbai, the office has notified that the clan of Lingdo, Nongtudu and Swer are the only three who are entitled to stand for elections as per customary practice, but the office has failed to specify the type of specific family of the clan who can contest to the post of Doloi. This has clearly shows that district council failed on his duty to protect the customs and traditions of the tribal indigenous Nemtre, and it has even failed to give due importance to the very fact of the tradition while electing the Doloi of Ilaka. That, sir, as far as the family clan who can contest to the election of Doloi as per the traditions, uses of the Ilaka Rimbai, which was practiced since time immemorial, the family should only belong to the Lingdo Rangad, Nongtudu, Safi, Swer, Tarking, and none other besides three aforesaid clans shall belong to indigenous faith of the Panar tribal. But as notified by the office, it appears that same tradition was not followed, and instead district council tried to exercise the AZ as practiced to the post of Doloi Ilaka Rimbai in a form of democratic setup, allowing anyone who wished to contest the elections, and in this way the district council not only violated the rule of law but failed to protect people's culture, traditions, which was the very basic principle that the district council coming into existence. That's all for your kind information. We bring to your notice that the Supreme Court ruling on election of Doloi Joai, so-and-so, Iwanlanki versus JCDC, whereas the appellant in this instant case, Sri Iwanlanki Rimbai, a member of the Jaintia scheduled tribe and a Christians by faith, along with Jaintia Ilaka secular movement, as the other party, filed the writ petitions before the court challenging the constitutional validity of Section 3 of the United Khasi Jaintia Hills Autonomous District Appointment and Succession of Chief and Headman Act 1959, under which the said provisions has stated that subject under the provisions of the Act and rules made thereunder, all elections and appointment of chief and headmen shall be in accordance with the existing custom prevailing in the Ilaka concerned. Besides, the appellant has also challenged the notice issued by the district council declaring the program for the elections of Doloi in the Ilaka Joai, specifically all the necessity for the elections of Doloi. The writ petitions was filed by these two parties on the alleged violations of Article 14, 15, 16 of the Constitution of India, and the appellant had contended that exclusion of Christians from contesting the elections is in violations of the said 3 article, and secondly, the appellant had also contended that the appointment of chief or headman headman accordance with the existing custom is also bad. But the Supreme Court on its ruling has ruled that elections of Doloi in Ilaka Joai and exclusion of Christians from contesting the elections is not violative of Article 14, 15 of the Constitutions, as Doloi by customary practice, he has to perform administrative and religious functions. The Christians admittedly cannot perform religious functions, and that the office of the Doloi with dual function, administrative and religious, is a part of tribal religions and culture governed by custom since time immemorial. That, sir, the Supreme Court ruling was bound to be implemented and executed in spirit and practice by JCDC, and the said ruling will have a long-lasting bearing impact on the culture and traditions of the Jaintia people. But it is regret to state herein that through this representation that our district council failed to respect even the Supreme Court, which shall be binding to all. This was reflected from the notifications of the council through the Deputy Commissioner Executive Committee where the program of the elections of Dolo Ilaka Rimbai, in which district council has openly flouted the custom and traditions of the Ilaka, allowing elections of Dolo Ilaka Rimbai is to be run in the form of a democratic setup, thereby allowing those individuals from other faith to take advantage out of it and jump to the fray, just like an elections run by the Election Commission of India. That's why it is deeply regret to state that the last two Doloi of Ilaka was belong to Christian faith, and this incident happened due to the fact that peoples are ignorant of the rule of law. Besides, they are too poor to address their grievances in the proper forum to challenge this incident of violations of the tradition and customary practice by the Ilaka since time immemorial. And since the custom itself do not allow people from different faith to contest the elections to the post of Doloi, except those specifically mentioned, family clan belonging to indigenous faith as such, we pray our good office to cancel the notifications program so issued by the district council for election to the post of Doloi Ilaka Rimbai, and a fresh notification may be issued after taking into consideration.
2014, what happened to this representation?
My lord, nothing. They have not, district council have
now
not
the notifications dated, the one he challenged.
This is 2023, my lord.
What happened in intervening period 14 to?
Now, my lord.
He continued till his death.
Yes.
The Dolo who belong to Christian faith.
What is the objection to his continuance?
Yes, they
not to the fresh election.
No, my lord, he was appointed till his death. He continued. He died in 2000.
In spite of, my lord, several complaints, my lord, which were filed, there was no action on the part of the district council, and then they continued. Now, initially, what happened, my lord? They started appointing acting Dolo, my lord. First, after the Yengswer, my lord,
the death of this
Yengswer, they first appointed an acting Doloi who belonged to a Niyam Khasi, my lord. And they terminated him, and then they appointed a Christian Doloi who is an acting Doloi, my lord. And then subsequently, my lord, they started appointing only from the Christian faith, my lord.
Acting Dolois. Acting can be anybody. It can be the man in the street also. Doesn't matter.
Yes, my lord. After Yengswe, my lord, the first Doloi, my lord, who was appointed as acting Doloi was he belonged to Niyam Khasi, and then subsequently he was terminated and appointed an acting. And thereafter, my lord, subsequent dates, my lord.
So after there was no Doloi?
There was Doloi, my lord, but they belong to the Christian faith, my lord. In spite of, my lord, all these complaints we have filed, there was no actions on the part of the district council, my lord.
Yes.
Now, as far as, my lord, from the affidavits which filed by the respondent number 2 and 4, my lord.
Number 4 is whom?
Number 4 is, my lord, Ilaka Dorbar Ilaka, my lord. Now,
what is their stand?
What it transpires is that, my lord, their stand is that as far as the rituals part is concerned, it should be performed by the Lingdo.
It can be bifurcated.
Yes. Now, and mostly, my lord, both the affidavits, it indicates to one thing, my lord, that the principles of secularism, my lord, can be applied even for the post of Doloi. Now, as far as, my lord, this principle of secularism can be applied only in places, only in activities connected to secular activities. It cannot be applied, my lord, if there is any religious practices are concerned, my lord, it cannot be applied. It can be applied only in activities which are connected with secular activities. Now, my another submission is, my lord.
See, they've made one amendment at para 11 of the affidavit. I'm just looking just now. Pyramid submissions. Other words, states that bring custom and practice the Darbar Ilaka is the highest authority which comprises of Wahir Shinong and elders of various Darbar Shinong. The governance of Shitang Rambai, they had revived black religious custom in the Ilaka and with a short span of time reviewed the manner of governance and one religious country practice. So this is not permissible by customary law. The work Doloi cannot be bifurcated. This is made on affidavit. Para 11. Anyway, yes.
Now, my another leg of submission is there, my lord. Because this post of Doloi, it includes functions which has religious angle to it, my lord. It has to discharge the religious duties. Now, these religious practices, my lord, it is passed on from one generation to another. A person, my lord, must live in that particular community.
We have understood your case.
Yes.
The sense that, yes, now falling from, it is not purely a secular post. I mean, it does not come within the, within the definition of ordinary employment or a post, which
Right.
is open to all. It has to be classified in such a manner that, for it to be workable and not defeat the purpose for which an office is established,
Right.
that it should that a person belonging to religious faith should occupy the post,
Right.
has been held by the Supreme Court in other case.
Yes.
But see, the notification in that case was different. Out here is that is on twofold. Now, first thing also notice that the clan is not mentioned. Now that is also one feeling. That is
None, my lord.
now notify the clans.
Yes.
Who are the clans?
Yes, my lord, we have finalized the list also. I have mentioned.
No, not the finalized list of nominations. It's in the notification itself. It should appear as for the clans who are eligible to contest. But that in all over Khasi Hills, Jayanti Hills, then you can't have.
No, that is there itself in the Act.
And
It
in
is
the Act,
Act
my
it is
lord.
there, my lord. Who are the eligible clans? We should not have a grievance for
But
that,
it should
my
be in
lord.
the
We
notification,
have-
my lord, so that people are aware. Now they will not go and
It is
see
in
the
Act. In the appendix, it is there,
before
my lord. Very
filing
clear
the-
and categorical.
My lord,
Yeah,
we cannot
three
expect
clans.
people
Okay,
to go
second
and.
part is that we'll have to examine.
Yes.
Yes. What do you have to say, Mr. Sen, on behalf of the council, like to support your notification?
No, my lord. Yeah, my lord.
Was
the
there
case
any
bu-
study done? Any study done by the council independently? Apart that 72-73 is very revealing. But
73, your
said that, but apart from that, is there any other empirical data you've collected? With regard to
Of course, my lord, brief data, what we have.
See, before that the thing is that the duty to the council, it was established for the purpose of regulating custom, election of traditional heads, all those things were there. Now, as far as possible is that in tune modern time is to see that these practices are preserved, because the district council was established for that very purpose.
No,
And so in this, like when they issued notification, as they're done with Joai, was there any kind of decision-making process as arriving at that notification saying that it should be open to all?
No, my lord.
There's no decision-making
No,
process.
because our whole contention, lordship is fully aware about that judgment, my lord, of the Supreme Court.
Yes, yes.
That pertains to, my lord, Juwai Alaga. My lord, I'll harp on this point, my lord, because here what, my lord, perhaps
Okay, just keep it for an instant that judgment does not exist.
Lordship.
Okay, just forget about the judgment.
Even-
Let's just say, assuming the judgment does not exist. Now, in the decision-making process of the district council, taking into account the historical factor, when they arrived at this notification, what was the justification?
My lord.
Is there any decision-making process before the notification was issued, like by the executive committee, that we take Rimbai Eleka, because it happens in Khasi also.
No, we have-
even for issuing, that what is the practice over the last EM, they have a genealogical whatever that. So those things happen, but in the process of deciding what notification should contain and what it should include everyone, is there any supporting materials? Or
Decision.
it's just made by the clerk?
No, I understand. I understand your lordship. Lordship want to know, my lord, arriving in such a decision, my lord, whether there is an objective decision.
Because you are a constitutional authority vested with the power to examine all these things. Right? We're coming to anything with any particular elaka. So whether in consideration of those historical, religious, cultural aspects, whether what is the consensus you arrived at with regard to Rimbai Eleka?
My lord, I understand.
You see, in Khasi is also so suppose Hiram, you can't have a CM who's a Christian. Right? Even in Millennium also is debatable, but they're having these CMs who are like okay, whatever. So those are the things. But then in other CM-ships there's no restriction, because those CMs don't perform religious functions anymore. They're purely administrative, So for there's no harm in anybody contesting, as long as they belong to the clan. That's the only restriction they have. But in this case, Rimbai, because they're more sensitive to, they have a lot of rituals, and whether that is, what is the
those were taken into consideration.
thought process, yes.
I understand. Whether there is any record on this.
Any thought process, yes.
That
Or
I'll-
just by a clerk, just make the notification and give it.
But that I'll have to find out, my lord. Whether there is a record. But as of now, my lord, specific to the, my lord, case of my learned friend, your lordships. Now, my lord, two things. I'll just, my lord, briefly, I'll rely on that Supreme Court judgment also. Because I know, my lord, this is inspired by their judgment. Otherwise, they would have come long back, my lord, challenging this, and they have never challenged. Now, my lord, Supreme Court, my lord, what happened? Supreme Court situation was different, your lordship. There, the district council, my lord, issued a notification. My lord, in pursuant to the power conferred by Section 3 of the United Khasi Jaintia, the succession, that do not exist anymore, my lord, at that point of time. And they categorically, they said, my lord, after proper investigation, those words were mentioned in that notification. District council said, these will confine to the people of indigenous faith. That was the stand of the district council, this was the custom. And that was challenged by some people, my lord, before the Honorable Court, High Court. Then the matter traveled to the Supreme Court. And there they have cited two instances. They cited two instances where Christian dollars were functioning. And court made a searching inquiry, my lord. There were two instances where, my lord, in Juwai Alaka also, Christian dollars were appointed. And both these occasions, what happened, your lordships, these were so, my lord, so unnatural to the Alaka, my lord. They revolted. In one case, the Doloi was terminated. In other case, he was forced to resign. So the Supreme Court held, this is not a disruption. This is at best an aberration. So this has not, my lord, touched the custom. Custom remains, it continues. Here the case is altogether different. Well, I'll take a lordship historically, my lord, even my learned friend. That's why, my lord, I'm looking for the record of that report. This report which was forwarded to the district. Even the report, my lord, of 73, it say, my lord, what was the situation prior to independence? Prior to the coming into force of the Constitution of India.
The 70 report is very revealing.
I know.
Only that fellow, whoever he was, that Mr. Nongri said that he occupied office in 1926, 1971. I know last year before his death, he converted Christianity, and that was, so that was 73. They had put in that representation. You understand?
Yes, so yes. That will be remembered. I'm, my lord, trying to get it. Now, my lord, going by this material before, my lord, the indication is that even prior to the enactment, enforcement of the Constitution of India, what was the situation? There was a Christian doorway. Might be he has converted, my lord. It's not the case that he was converted and he was removed.
That's an aberration again. At the time of election, he wasn't. Yes. You see, at the time of election, he wasn't. It's just like you elected to, you were a Congress, you elected to Congress and you defected to things. So at the time of your election, you were holding a Congress ticket. Yeah, that amount to that, as per code. So what you suppose the Congress party gave you a ticket, Congress, you were elected as Congress. What happened later on, you defected, that is different.
My lord, I'll say here it's not aberration. Why it is not aberration? Admittedly, my lord, what they are indicating, this Doloi he converted into Christianity. Now, my lord, if as per the custom, my lord, he is not a Christian, my lord, he should have been terminated forthwith. He has not been terminated forthwith, your lordships.
So you see the 971 is on
1971, your lordship.
Okay.
Now, my lord, he is converting into Christianity. Now, my lord, what are the pleadings, my lord, made by my learned friend? Pleadings that he had done it very quietly without informing anybody. He has done it. So, my lord, lordship will not call it an aberrations. So these.
No, that's on the report only.
That is in the report, my lord. What is the findings, my lord? Ultimate findings.
That is what this court's asking. If in the case of Juwai Ilheka, there was a conscious, whatever exercise conducted by the council with regard to the customs, and they arrived at notification. Now this notification is very blank. Even if you say it's given appendix regarding the clans, the notification is the end. It gives a person who does even non-clan a handle also. To say that notification has not classified. It does not say notification anywhere that it will be as an appendix given act, nowhere. It's a general notification, schedule of elections. That's all. So whether that, it deserves interference or not, that I will direct you to issue a fresh notification, then taking all these things into consideration, whether, from the clan, okay, fine, appendix there, whether you've done any inquiry, you issue fresh notification. Then you keep the election events, keep on acting the noise.
Lordship, other thing I will point out, my lord. What is he's, my lord, coming up with certain, my lord, customary practices and virtually asking the writ court. Here there is some constraint before the writ court, asking the writ court to declare this is the custom.
See, no, Mr. Sen, this issue, even out of the Supreme Court regarding the entire sequence of whatever, why did the council say is confined with that? Now, the materials are produced before the court. Like I say, I don't want to refer a decision, but this was the discretion of the Red Court, it went to that,
No,
to examine, the rituals. What are the rituals that go before bedding clump? What are the rituals that, before a certain puja? How many days, and what is the role of, certain, the actors in the entire process? So that the court had gone into. It's not a question of declaring.
No,
it's just a question of, of ascertaining.
No,
So that's the thing. So that's why to see that, yes, the case that they are trying to make out, that he has a very vital role to play, is based on some, tangible, data and practice.
Exactly.
That's the thing.
Exactly. But only thing, my lord, what
So
my lord,
the
what
version of court is that we might send this matter back. Now you sit on it.
No,
you
Lordship,
decide.
No, what I want to convey again, my lord, that case, my lord, it's the district council which made the searching inquiry.
Because
After making the inquiry,
exactly.
they said, no, this is the
This
custom.
court is saying that before issuing the notification, what is the basis on what the
That's what your lordship want to see.
And if you cannot say anything, then we'll send it back. You decide.
No, my lord, coming to the other aspects, your lordship,
Yes.
this is an admitted fact, my lord. We have set out in our reply, my lord, clearly and categorically, my lord. 73 onwards, my lord, there are a number of Christian dolois. Now, if your lordship, if I can take my lord to our affidavit. Para 6.
This is
by 2, respondent number 2.
Okay. Yes.
That with regard to the averments and statements made in paragraph 5 and 6 of the writ petition, the deponent denies the same and the same is put to strictest proof thereof. It is stated herein that in the past, on several occasions, the person following Christian faith were elected and appointed as Doloi Ilaka Rimbai, and no complaint objection was ever raised at that relevant point of time. Such cases, my lord, these are the instances, my lord. Reswear, follower of Christian faith, was elected Doloi Ilaka Rimbai, 27 to 75, way back in 75, my lord. Now we are standing almost 50 years hence. Now, my lord, Batskem Lindo, a follower of Christian faith, was elected and appointed as Doloi Ilaka Rimbai on 25/5/93. Now, my lord, this is the last elected Doloi. Sri Ilyas Swear, a follower of Christian faith, was elected and appointed as Doloi Ilaka Rimbai on 28/2014 till he expired about 2019. So, lordship will see, my lord, here, my lord, there was a, my lord, for a long period of time, my lord, there was a conscious, consistent practice of electing a Christian Doloi. Now, my lord, here, your lordship, custom of a Ilaka, my lord. My understanding, my lord, if your lordship look into the definition of custom, they are saying with reference to a Ilaka. Nothing universal or general for all Ilakas. Now, so far this Rimbai Ilaka is concerned, my lord, this is very clear and categorical, my lord. For a long period of time, a number of, my lord, Dolois who are of Christian faith were elected, my lord, and they completed their tenure, my lord. And they was, my lord, they successfully discharged their duties.
Yes.
So, my lord, here is the question, my lord, to enforce a custom, your lordship, it should be, my lord, uninterrupted. There should not be any disruption. But of course, aberration. What is aberration, my lord? That can be ignored. But no, can we say, my lord, these are aberrations? All of them, they completed their tenure. No, lordship will.
See, the thing is that, see, you say section 4 of this act itself. No? That is
the new act.
The new act. Same, it is same. Existing.
Slight. I'll point out. Same problem. I'll point out. There is a difference, my lord. Lordship, my lord, prior to this act, my lord, what was holding field was the United.
Your last submission, you said, okay, fine, it is not a prevailing custom. Right?
What I am saying, no, my lord, that will be correct, my lord. So far, my lord, customary practices and all are concerned, my lord. What we are saying, my lord, so far customary practices are concerned, lordship, these are performed. These are performed, so far Rimbai Elaka is concerned, my lord, Lindo is there, my lord. Lindo performed the customary practices, while the Doloi is the, my lord, administrative head. Now, my lord, here.
So, election of Lindo, Lindo cannot be Christian.
Here I will come, my lord. I will point out the uniqueness of the new act, new act of 2015. Now, my lord, prior to 2015, my lord, the United Khasi Jayantiya, my lord, succession of hand chief, that was holding the field. And section 3 say as per the custom.
Yes.
And there was, my lord, no definition of Lindo as such, my lord. There was no provision for customary functionaries. line, my lord. I'm just coming. One second, Lord. Succession. 123. 114, my lord. Now, my lord, in the United Khasi Jandia, my lord, succession and Hadman, your lordships, there is no provision for customary functionaries. Lordship can come to, my lord, if lordship is holding that book. Lordship perhaps is only the new book, my lord. I'm just referring to the old one. Now, in the definition,
you're talking about which act?
My lord, before, my lord, this act came into force, my lord, December 2015. And by this, my lord, stand repeal, my lord, the earlier act, the United Khasi Jandia, succession of headman, etc.
59 Act.
59 Act. Now, 59 Act, my lord, if your lordship look into the definition column, there is no provision for customary functionaries.
No, 59 Act, I tell you, if you want to go to history of 59 Act, if you go to T. Kaji case, 59 Act was brought about just to facilitate, the removal of Germanics aim by the whatever district council at that point of time. And so you look at, just one judgment, he says that, fine, that why was aim an officer of the district council? Although there's no master-servant relationship. Now, when just once you said that, okay, fine, while this matter is sealed by Supreme Court, this act has come into being, 59 Act. That act was just it was just an act just to, to assist the district council in, in sort of suppressing the aims. This is my own opinion. So that to make them subservient, that suspension pending inquiry, you don't need to give notice or show cause, and then the district council became supreme. It became tested again. Abu's Malik's AM case went up to Supreme Court. Even the judgment held the field. It's a beautifully constituent bench judgment. The beautiful judgment goes through entire history, the role of the governor. All these things are there. But we will not take recourse of 59 Act, because that act is it is not crafted in a manner which would really sort of apportion the rights or whatever.
Lordship.
That's the thing.
Lordship. Now, my lord, coming to your lordships, given this aberration, this new act.
Yes, we stick the new act. Since yes, because the notification been issued after new act.
Yes, after this segment. Lordship, come to the definition column. Definition, section 2, my lord. Definition.
One second. No, sorry.
Lordship is having a copy. In my compilation, this copy. Section 2. In this act, unless the content, etc., subsection 2, your lordship. Sorry, my lord, subsection 3.
Yes.
Customary functionaries means Lindo, Pator, Sangat, or Basan, or any other who are appointed as such by the Doloi and his Darbar according to custom and recognized as such by the Executive Committee. Now, my lord, here they have contemplated the idea of customary functionaries.
Yes.
Now, obviously, my lord, I want to say, this became a necessity for the district council for the reason, my lord, the practice varies from Elaka to Elaka. And so, for Rimbai Elaka is concerned, my lord, consistently it is the Lindo who has been performing the customary practice, and Doloi is only the administrative hand. And this is the reason why, my lord, the power to elect has been with the Doloi.
The power to?
Power to elect the customary functionaries, that has been vested on the Doloi. Power to appoint. Appoint as per the, my lord, as per the customary election, as per the customary practice, your lordship, that has been vested with the Doloi, and then it requires to be.
That's a general custom. It's a CM also and the Darbar, like whatever, Lingdo or Mantri.
No, my lord,
he comes to the clan. Yes.
My lord, what I want to convey, this definitely has a purpose. It's not like this. Customary functionary, why is required, my lord? Because this is a Elaka, my lord, now The Lindo who has been, my lord, performing the customary practices. So, my lord,
So your case is that the Doloi never exercised any religious duties. You are maintaining that case that his religious
has to be, my lord. Has to be why, my
he
lord.
Never exercised religious duties.
No, my lord. Why has to be? Because I have given a list, your lordship, starting from 75 onwards, my lord. Consistently, my lord, the Dolois have been elected who belong to the Christian faith.
Right.
Christian
but
faith,
that means the Doloi has no role to play.
My lord.
Suppose now,
No,
as
Puja
per,
land.
as per
Puja
the
land and
statement
service
of,
land.
as a statement of respondent number 4, who is the Darbar, he said that when Doloi is saying, he performs it. If it isn't, it's performed by Lungdo. That's a statement on para 11 of the, that runs counter to your submission now.
That is also a statement by the district council, my lord.
Yes. Yeah, it runs counter to what? No, Mr. Sen saying that it has no function.
No, well, so far, but the lordship will look into it. My 75 till, my lord, recently. Who was the Doloi? Doloi was my lord, person appointed who belonged to the Christian faiths. So all these years,
75 is just yesterday. So you say that, that regarding
almost
the role,
50 years. 50
the role
years.
Doloi has no. You are submitting that he has no religious duty to play.
No, my lord, I'm saying, say for example, my lord, one of the Puja land, the cultivations, that is managed by him, but then whatever the, my lord, revenue is earned, that is sent for the purpose to meet the expenditure of, my lord, customary, my lord, religious practices. My lord, what is the impediment here, your lordship? And lordship will also have to appreciate other thing, my lord. Other thing, my lord, this is the reality, my lord.
No, the only thing this court is interested in is one thing.
Lordship.
Is that, we are doing this inquiry because to see whether the council, in opening up, whether it has taken the entire custom into consideration. That is all. That if they are supposed to regulate custom, they are supposed to maintain it and uphold it.
Lordship.
Exactly. Article 13 says custom also is law. So you see, the duty of the council is that in the discharge of functions, whether they are alive to the entire situation, that's all. And whether, in issue notification, then they can reason is right, it is right. And if the court finds that, yes, there's some lacuna and some lacking somewhere, then you examine it.
My lord. No, my lord, so those records, my lord, whether those things were taken into consideration, my lord, when arriving into your decisions. But the only thing, my lord, it may not be, it might have
Very
been
interesting because it's
yeah, I understand, my lord.
and even then you bring in the concept of negative equality, in the sense that you say that 3 Dolois who are Christian appointed never perform the religious functions. Now whether you can seek, like a constitutional authority can seek negative equality by saying that because Christian Dolois were elected, now the equality should continue. So that's another aspect you have to examine. Whether by saying that they're not aberrations, but whether they were regularly appointed, given sanad, performance Dolois, whether that it might be aberration, but whether by now, by the notification, you're seeing to perpetuate negative equality. That is another aspect which will look, which is just came to my mind.
Here your lordship will see, but these people are elected by the people.
Of course, elected, appointed. I mean, like perform.
And the existing situation is this, my lord. Majority of the voters, my lord, they belong to the Christian faith. Belong to the Christian faith. So there is also one thing, your lord. Now, so far your lordship want to know, my lord, how the decision has been arrived at. Not necessarily, my lord. Even earlier decision also, but lordship will see here, my lord. Even earlier notifications, my lord, were in similar line.
That's right. That is what.
Similarly. Now, whether, my lord, the inversion.
Why have they made a difference between Jawai and Rambai?
That
answer. Same authority. You're the same authority.
No,
issue notification for
lordship. That answer I have, your lordship. Then again, I will say, my lord, lordship, go into the definition of custom. Custom categorically in the definitions, a custom in relation to a elaka. It cannot be universal.
And then we go to another area whether a lingdo is equivalent to Doloi in discharge of functions.
My lord.
Whether a lingdo is equivalent to Doloi and whether he can discharge the functions or not, as per the religious practices.
Lord.
That is also because that is a lot of big difference. It's interesting, but yes, you're saying customary functionaries.
No, customary functionaries, my lord.
Right.
No, customary functionaries got its place in this rule. Now, obviously, my lord, this has a purpose because what we are saying, my lord, district council, there are elakas particularly we are concerned with Rimbai now, Rimbai Elaka, where the customary practices, religious practices are discharged by the Lindo. So we have made a provision. Now, if my learned friend was, my lord, strictly going by law, my lord, he should have challenged this. He has never challenged this.
No, customary functionary.
My lord, customary functionary means, my lord, obviously it means the person who is, my lord, eligible, my lord, who is competent to discharge religious and customary functions. This is the meaning of it.
It's like customary office also. Yes. Now where's the, this is Vahesh, correct?
This is Vahesh.
The act, no? Yes.
Now, your lordship, if I can take my lord to the power and function also has been spelled out, your lordship. Where is my affidavit? My affidavit. Lordship, at page 6, my lord.
Page 6 of the?
Not page, of my affidavit, your lordship.
Yes.
Sorry, your lordship. Page 3, power and function of the Doloi. It is there in the Act also, my lord.
Yes.
Act, section 18.
Page 3.
Section 18. Power and function of the Doloi Siddhar.
Section 18, yes.
18.
Yes, yes.
Well, subject to the rules may be made in the executive committee, the following shall be the power and function of the Doloi Siddhar within the Elaka. To look after the administration of the Elaka diligently, efficiently, in accordance with the Jayantiya Autonomous Council district such and such, and to abide by the rules and regulations. Number 2, to convene Darbar Elaka at least once a year. In the event of emergencies, the Darbar Elaka may be convened oftener than what has been provided. To look after the boundary of the Elaka all times and report to the executive, etc. To conserve and protect and reserve forest and promote establishment of new reserve forest. To adjudicate and decide the civil criminal cases, etc. To recommend the executive committee establishment, bifurcation, amalgamation of villages. 7. To conduct the election of the office of Wahesh and to report the same to the executive committee. To constitute the Darwash of every village, to supervise administration of villages. 10. To settle boundary dispute between villages amicably. 11. The Doloi Siddhar shall have the power to recommend the issuance of landholding certificate. Now, 12. To cause such areas.
Here and the end, in so far as religious and
my lord, I'll just read that.
The
Doloi Siddhar shall have the power to recommend the issuance of landholding certificate, patra, registration, forest, mutation, name of the said documents by revenue officer, land records and settlement officer of the district council to landowner, landholder in accordance with the prevailing custom usage of the Elaka. My lord. So, provided that the Doloi Siddhar shall submit such recommendation after due and proper spot inquiry and verification, and such recommendation is to be accompanied by document indicating the proper inquiry verification has been made. 12. To cause such areas to be set aside for growth of trees, supply, building timber and firewood to the inhabitants of the Elaka, also to take efficient measure to secure these areas against destruction by fire and zooming. 13. The Doloi Siddhar shall have the right of power to cultivate service land as remuneration for service rendered by him to the Elaka and cultivate the puja land for meeting the expenses connected with the religious performances. This is the only place, my lord, there is a reference of religious rights. Now, what power the Doloi will have? He can cultivate, and whatever the remuneration comes, my lord, will be contributed to meet the expenses of religious rights, your lordship. So, my lord, if your lordship look into this power and function, my lord, nowhere say that the Doloi, it has been spelled out, my lord, the Doloi has the function, he himself will discharge, my lord, the religious rights. It is not there, except, my lord, that cultivation, my lord. My humble submission.
Because the general act, Mr. Sen, it has to be like, if they make a separate act, like they have done, say, Council Khasi Hills, the nomination election of Nong Klau, then of Maolong, then they'll come the practice for particular. This is they can't. In this we understand. They will not give.
My thing is, what your lordship says is correct, my lord. It cannot be universal, your lordship, because it varies from elaka to elaka.
It's there in the preamble, my lord. It says principal functionary, my lord, is the customary in the preamble itself, my lord.
No, not that, Mr. No, what Mr. Sen to show that from General Act you will not get that.
My lord, while my learned friend is becoming customary functionaries. Now, customary functionaries, my lord, do not necessarily include, my lord, religious right. It also includes, my lord, the way he will administer the elaka, the way he will distribute the land. These are all part of custom.
It includes even the religious practices also, my lord.
Yes.
Now, my lord, if your lordship can take to section 33. Election, appointment and removal of customary functionaries. Section 33.
Okay.
I'll just read it. 33.1. Doloi Siddha shall have the power to conduct the election, appoint and remove the customary functionary of the elaka.
Yes.
The Doloi Siddha shall have the power to conduct the election, appoint and remove the customary functionaries of the elaka in accordance with the custom prevailing in the elaka. The Doloi Siddha shall inform the names, duties and functions. My lord, here, this has been made, my lord, consciously by the district council because it varies, my lord, from elaka to elaka. There could be the elakas, my lord, where not the Doloi, but the Lindo performs. So this provision has been made very consciously, my lord. This is not challenged. Shall inform names, duties and functions of the Lindo, Battar, Basan and other customary function immediately to the executive committee for information. The Doloi Sardar shall also intimate the executive committee the nature and the status of the puja land, service land prevailing in Elaka, enjoyed and held by the customary. Now, my lord, here the puja and ritual has been brought under this head. So what I am saying, my lord, that stands substantiated. That stands substantiated because these customary functionaries, my lord, they discharge. Now, who will be the customary functionaries, my lord, will depend from elaka to elaka, your lordships. So, my humble submission, my lord, here, so far this elaka is concerned, my lord, it is the Lindo who performs. So, if
that
Lindo,
is your stand.
No, this is our stand. And this
elaka,
Lindo performs the religious rites.
Is the religious functionary. Okay.
And that a provision has been made, my lord, categorically in this regard, in the Act.
And
there is a customary
as per
function.
the Act.
Yeah, as per the Act.
As per section 33.
33. 33 is the appointment, my lord.
33. Okay.
33 of the elaka. And these further stand substantiated from the, my lord, pleadings we made in our affidavit, because we have said from 75 till the last, the Christian Doloi. Is the Christian Doloi, my lord, Lindo was performing? My lord, it has not resulted in any confusion in the elaka, except what, my lord, stray representation my learned friend is referring, nothing else. Nobody has come before the court. It was not even challenged before any authority of the district council. Nothing happened except those representations.
Were they never answered?
50 years, my lord.
Anybody answered no?
Representation, my lord. One thing is, my lord, your lordship is also feeling, my lord, that 73 report. The 73 report something, my lord. In fact, I have sent a message you. But only thing, my lord, that 73, my lord, is quite old documents. But I am asking for it, your lordship. Now, what is transpired from there? Now, my lord, the other thing, my lord, strictly comes, your lordship. That is true, my lord. The custodian of the custom district council, my lord. There is no dispute in it. But again, your lordship, my lord, to enforce a custom, my lord. I am not saying, my lord, doing it. Custom, my lord, it has to be, my lord, continuous, uninterrupted. Uninterrupted. Now, if an arrangement where, my lord, both, my lord, at
You already
times...
submitted that. You already said customs, that's already
uninterrupted, my lord. So, Lordship, from 73, admittedly on records, because there also Supreme Court, my lord, looked into the records. Here also, Lordship will look into the records. Now, what are the records before, my lord? From 75 till 2019, Christian dollars holding. Now, that cannot be termed aberration, your Lordship. And that was not... Now, they have come, my lord, Sunrise. My lord, they are very cultural, my lord, religious organization.
Who was this?
This is a petition filed by the chairman, Sunrise.
These are... Sunrise, okay.
Yeah.
Now the religious organization.
My lord,
Yes.
they have never challenged.
I heard
For long,
Sunrise.
50 years. For 50 years, this arrangement continues, never challenged. So, my lord, suddenly after 50 years and coming and saying, no, there has been disruption, custom has been flouted, a Christian cannot be a candidate or Christian cannot participate, my lord, that will have a, my lord, large ramification, because we do not have one elaka, my lord, there are other elakas also, where, my lord, people of Christian faith are holding the position and, my lord, without any inconvenience, my lord, either to the subject people or to anybody, my lord, they are discharging their function. Suppose your lordship, my lord has no. There is only, my lord, it should be confined to, on the basis of whatever, my lord, the judgment of the Supreme Court. This will have a larger ramification. My lord, immediately, my lord, other elakas, my lord, petition will come.
Jump in.
It will open a Pandora box.
No, this court not looking at the judgment or not looking at, other elakas also.
So here,
the case has been
exactly,
brought.
my lord, exactly.
Now the case they've brought now, whatever it is, they're saying custom not been followed. And the notification arrived at the district council is wrong. So all the inquiry of the court that what is the custom there and what are, to arrive at this, notification, what were the considerations taken into by the district council?
That is one. That I'll have to find out.
That is
no,
all.
that is one thing I'll have to find out. No, I'm talking about the larger ramification. Ultimately, it may have ultimately.
See, that is never an excuse.
Anyway,
suppose you see Assam rifle cases, one person comes with a small innocuous petition, he gets some order, and the next day the 2,000 petitioners and one petition. Can you say that, can an argument be made that no orders will be passed because there are 2,000 people in the shadows looking at what's happening?
Obviously. But the other thing, your lordship,
rights are right. Rights are right.
But then again, the 50 years, my lord. Admittedly, lordship before records 50 years. Christian dollars. They have been holding this position.
So, according to you, what will constitute time immemorial?
There's
definition.
No, my lord, that time immemorial.
Yes.
Sorry, even
So
time immemorial. That's why, my lord, I am looking for. I have already sent a message, my lord, to make available that records. That 73. Even 73 is.
That means we can't conclude this hearing today.
My lord, it will. I think it will take some.
And we spend so much time.
And that 73 also, my lord.
They had said that there's some urgency, and then even
no,
that time, I think.
No, I think my learned friend also
said that this matter should be heard because they can't afford to pay the administrative officers.
No, those things are there.
Correct.
We are also in a hurry, your lordship. It's not that
submissions were made that they can't afford to pay the
No, because election has been stalled. Election has been stalled, my lord. So there is a sense of urgency. It's not that I'm saying, my lord. It may be, my lord. I place the records. At the earliest, so that your lordship can conclude and deliver the judgment. And then
I will also reply, because the para 11 which your lordship was referring to regarding that.
That's as per what the council says.
That was in the year 1500,
1500?
1500, as per the history. So in the year 1500, the then acting Doloi had bifurcated the duties, religious duties that are linked off, and
in 1500.
1500. That is what the history books say. So it is on that basis.
Written by whom, history book 1500?
This is as per the record of the Darbar, Ilaka. And also, there is a book on the history of this Ilaka, which is written by...
Why has not been produced for the court?
It's a commentary, I can always hand it over.
Let us see. No, even then.
Gives the entire
there was one case. I think you've heard of this. I forgot is this juris. With regard to ordinances, being a farce on the constitution. Like instead of enacting legislation, ordinances are made, to serve the purposes of any serving government. And in that petition we filed Supreme Court Article 32, he had one annexure only. You know what was that annexure? It was a book this thick. Another thing. So you could have annexed this also in your affidavit.
I would have had to translate the entire book.
Oh, yes.
It's in Khasi. We didn't really have the time, so we had to file it. And also, regarding the 1971...
Which page that 1500? Very interesting. You have to refer to.
At page 25, page 25, last paragraph. On page 26, that is the portion, somewhere in the middle.
This clearer comes under Rimbai.
Yes, Rimbai.
Oh, it's a very important. A very important consideration. You also you try to take information on that. Whether it's correct in the year 1500 that the secular duties and the and the religious duty was separated.
If that be so, my lord, that inquiry report, my lord, 1971 by the district council, it says otherwise.
Yes.
If that be so, and my lord, what is the basis?
So this has to be based, no?
Yeah, it has to be based on something.
On some fact also.
Yes.
But even if a person written it, maybe there's some. You see, there must be some. There must be some kind of study that's been done. I know. You aware of this book?
I'm not aware.
Not aware.
No.
You get it.
Yes.
And you consult with your clients.
Yes, my lord.
Also, Lord, in my affidavit, Lord.
No, we won't go to affidavit, Mr. Philomen, because since we're not concluding the hearing today.
I just wanted to indicate, Lord, 1971, the complainant was, Lord, one particular Shno, Rangat village, Lord. And subsequently in 2014 also, Lord, and not the Sengraj. And now, my lord, the Sengraj comes in 2023-24 with this petition, my lord. Now, in my annexure, my lord, since the entire Ilaka does not comprise of only one village, various villages, my lord, I have, my lord, enclosed the representation, my lord, of all the villages, my lord, within the Ilaka who have written to the Ilaka, my lord, that we want to continue with the present custom which has been prevailing over the years, my lord. So all these things have to be taken into consideration.
Of course. The council have taken all this consideration before giving notification.
No, my lord, and I'll just argue.
Are you aware of this book, Mr. Sen?
No, my lord. I'll try to get it.
Yes.
My junior colleague, she'll help me. Now,
He's
Lordship.
got a nice name also. His name is Pear Vision. It's a different vision.
My lord, I'll also make my submission, my lord. I'll try to get the records that virtually, my lord, normally what happened, my lord, when election is notified, I've been talking about, my lord, assembly election under Representation of People Act, my lord, it goes outside the purview of the court, your lordship. Now here also, my lord, what he has virtually brought before this court, an election dispute. I'll try to satisfy my lord. Because for an election dispute
of this court, where they have distinguished between custom election and election under a normal electoral office. They have distinguished. It's Justice T.N.K. Singh judgment is there also.
Well, anyway, I'll look into it, my lord. I'll try to calculate.
About that. They're the
Because ultimately, my lord, I'm not saying, my lord, custom to be diluted. No, my lord, that has to be preserved. But the fact is this, my lord, the people are happy, even with the Christian Doloi, things are working for 50 years. Now suddenly coming and I say Doloi cannot be a Christian.
If they are happy, my lord, they
that,
will not come
that
before
kind
this
of thing, my lord, which, my lord, has the, my lord, my humble submission, my lord, is not required at all. When the things are moving, custom is preserved, my lord, it's not the case that the custom could not be preserved. It's not the case that there is undue interference with the, my lord, discharging of customary rights. It's not that. So, anyway, your lordship, I'll try to obtain the records.
When?
My lord,
matter remains part heard just after 2 weeks. Yes. I'll not record any other thing. You know what you have to do.
All right.
Supplementary list, item number 2.
Yeah, please, Lordships. Well, it's my apologies for not being here earlier.
Yes, we have to stretch that hearing just to accommodate you.
My sincere apologies. Well, it's the limited issue here is, there was this tender, for the supply of certain medical equipment. Now, I had participated, so as the private respondent number 6. Now, I will very quickly, just take your lordships to a letter dated 20th of November 2023 at Annexure 2,
Annexure 2.
Page 41, if your lordships kindly have.
Yes.
My lords, this is addressed from the superintendent of the Tura Civil Hospital to the director of Health Services, my lords. And it says, my lords, Madam, with reference to the subject cited above, I have the honor to inform you that the tender opening was done on the 8th of November 2023 at 3 p.m. in the conference hall of Tura Civil Hospital for the supply and installation of 1.5 Tesla MRI on turnkey basis at Civil Hospital, Tura Civil Hospital. After careful scrutiny and comparative study, the technical and financial bid, and keeping in view the procedure, the best equipment suitable for the hospital, the committee approved the 1.5 Tesla MRI Siemens Magnetum Sempra to be supplied by Messrs. Meg India Medical Supplier Tura on turnkey basis. However, my lords, the issue was with regard to additional funds, so they wrote that additional funds should be given.
From compared to technical and financial bidding.
Both.
That means both technical and financial bid you were successful.
The committee, the tender committee, my lords, approves me.
Yeah, okay.
After the tender committee has approved me, my lords, there is no work order coming. So I keep on writing to them. I keep on going back to them. I said, please tell us what is the status, what is the status, what is the status. Nobody says anything, my lords. And my lords, now I am informed that the other bidder, my lords, who had actually bid for a Chinese MRI company, is now been selected and the work order is being issued to him.
Already issued?
That's what, my lords, I am given to understand. We've asked for a copy of the order, not given to us either. We've filed an RTI application, my lords, it is lying there. Something is amiss somewhere, my lords.
Who is the tender committee? Constituted by whom?
Tender committee, my lords.
Constituted by what people or which experts?
That they will be in a better position to say because
it's
simply
from the
says.
government itself or is
It's from the government
internal
itself.
hospital thing?
It's from the government itself, my lords.
No, but Mr.
I will,
General, this is very disturbing.
I will show, my lord. What my friend says now is not correct, my lord. Kindly see from.
Then you discredit this letters.
I know. I kindly see the representation of my friend, my lord. Kindly see.
Let him finish.
43. Yes. Let him finish me, your lord. Kindly see.
My lords, I will read 43 for the convenience of my learned friend and your lordships. My lords, this is a letter, my lords, written by me on the 30th of January 2024, my lords. I write this. Dear sir, with reference to the caption subject, it is stated that tender so-and-so was issued by Hospital Management Society, Tura Civil Hospital, thereby inviting eligible qualified bidders to participate in the bidding process for supply and installation of so-and-so. Proposed to the issuance of the above, undersigned being a supplier of medical equipment possessing necessary qualifications in terms of eligibility criteria set forth the tender notice, proceed to participate in the bid by submitting necessary documents on so-and-so. It is submitted that the bids received by the prospective bidders were opened on so-and-so at 3 so-and-so in the Tura Civil Hospital, and thereafter recently the undersigned has gained knowledge and also has to come into possession of letter dated so-and-so, my lords, which I was referring to, 2011-2023, issued by your good office addressed to the Director of Health Services. A reading of the contents of the said letter indicates that a request for additional funds has been made, as the committee, having regard to the importance of having a good MRI scanner at Tiraso, approved the bid of the undersigned to supply the so-and-so machine. The reasons mentioned in the above letter clearly suggest that the decision to approve the bid of the undersigned to supply the MRI machine was taken by the committee by having regard to the stipulations as contained in Article 10 of the tender document, which provides for bid evaluation, price, functionality, value-added benefits, etc., etc. Furthermore, as the undersigned, as it is not understood by the said letter, decision on the allotment of excess 5 crore so-and-so is awaited from the Department of Health Services. Whilst it is undisputed and an admitted fact that the process of conducting the bid has been completed fair and transparent and there has been no foul play, however, pursuant to having come into possession of the above letter dated so-and-so, the undersigned has reasons to believe that the other bidder, in collusion with some persons, is making constant efforts to derail the entire bidding process on the purported ground of L1 bidder was not selected. Accordingly, apprehending foul play and unwanted loss aimed at the business undersigned at the behest of other non-successful bidder, the present communication is being issued by the undersigned so that you may look into the above and deal with the perpetrators as deemed fit and proper. At the same time, the undersigned most humbly requests you to kindly proceed with awarding the contract letter subject to approval of additional funds so that the undersigned can expeditiously make an arrangements to supply and assist in operating so-and-so machine. And my lords, thereafter some judgments and things like that are quoted may not be relevant for us.
Commissioner?
I'm sorry, my lords?
Why the address of the Deputy Commissioner?
Well, I think Deputy Commissioner will also be part of that tender committee. Just seek instructions. Just seek instruction of this.
Yes.
Please just seek instructions right away.
Yes.
And copy, my lords, at page 45, copy is marked to the Superintendent, Tura Civil Hospital.
Right. Then what happened after that?
Well, since then we've been running around. Only, my lords, sometime back when we went, again to inquire as to what has happened, we were informed that the bid has been given to respondent number 6. We asked for a copy of the tender, my lords, the work order. Nothing given. RTIs have been filed, my lords. As usual, it will come, but at some point of time, by then, probably a plea would come before your lordships that the tender has already been completed. So the question, my lords, I ask myself is that once the tender committee, my lords, has accepted and approved my tender, where is the question of, my lords, it being given to somebody else? Unless my tender has been rejected. Well, I'm instructed, my lords, the Deputy Commissioner was the chairman of the tender committee.
Okay. Of that Hospital Management Society.
My lords.
Listen, sorry. The thing is that, was this letter marked to Annexure 2?
No, my lords, it's not. This letter has not been marked. It has been subsequently, my lords, because we were the successful tenderer, the communication had already gone, we were shown.
To everyone, sent to Principal Secretary, Health, Joint Secretary, so and so. Yes. Yes, Mr. Arpicha.
Yes, Sir Lordship. Lordship, kindly see the recommendation which my friend has read out, my lord. It's kindly see the amount, my lord. The quoted price of the selected supplier, my lord, is middle of the column, 11 crore 95 lakh rupees.
Yes.
So bid submitted, both L1 and L2 have been technically qualified, my lord. They have not said so, my lord. They have this letter.
Technical bid.
Technical bids of both the bidders were qualified, my lord.
Yes.
And my friend has got this letter, but he has no other information whether what was the amount of bid submitted by L1, my lord. No other information, my lord. Now kindly see what the letter which gives the inkling at page 43, my lord. At page 44, the bold portion, my lord. Lowest rate is not the criteria for evaluation. So the petitioner knows that the technical bid of the L1 has been selected. And that bid, my lord, I have spoken to DC over phone. It is 2 crore rupees cheaper than this year.
Chinese machine.
Now Chinese machine technically qualified. My friend, let's write Chinese machine in the writ petition, my lord. Have they said so?
No, one thing.
I've said so.
One thing, Mr. Arpicha, you see, if this letter, if you do not discredit this letter.
Which letter? This letter by tender committee. Not tender committee.
Yes.
Now tender committee,
Now, tender committee is a committee of experts to evaluate
the technical bid and financial bid and give recommendation to the state government or to the government.
You are to accept it.
Yes,
or
my
to
lord.
reject it.
Yes,
Correct?
my lord.
Now, has it been rejected?
Yes, my lord.
Where's the rejection order?
Yes, my lord.
Has he been given the order?
Now, my lord, if I award the my friend is having this letter, my lord.
See, in all terms, in all contracts, see.
Yes, my lord.
Once you have passed a technical bid.
And my lord, this was passed for
and this is in November 2023.
My lord, now the only problem which I face is that if I say that the information was not there with regard to his rejection, kindly see his own averment about rejection. He says so before your lordship.
Did he
kindly
get
say
any hard copy saying that, like, was he called for negotiation?
Your lordship,
on the price?
I have got two bidders, my lord. One bidder, no. So then in that case,
to match the price?
no. So the one bidder is whether he is willing to. One bidder is.
Whether he's willing, but he asked him.
No, financial. Now let me answer my friend.
Yes.
See, there are two bidders. Financial and technical bids have been opened in front of both the parties, my lord. The bids have been opened. Now, my friend.
And
so,
his letters issued that the tender committee, after careful scrutiny and comparative study, the technical and financial bid and keeping to the best.
Yes, and now your lordship kindly see.
Price is not a consideration.
Now, who is saying? Who is saying now your lordship?
The best equipment.
No, best equipment now.
Suppose you want to buy a car.
No, I want to buy a car. I have a Tesla. I have a Tesla and I have a Mercedes, my lord.
Give an example.
Yes, my lord.
Give an example. You want to buy a car. Archival General's office has floated a tender to purchase one car. Okay.
Yes, my lord.
Right. And so, so technical bid, financial bid, 2 cars have been brought before
yes,
you.
Lord.
Okay.
Yes, Lord.
Then Archival General said, no, this Innova is good.
Innova
it's
is
better than that Maruti,
yes,
right?
Yes, my lord.
So then, finally, you settle for Maruti.
Yes.
After they've been given the bid.
Yes,
now.
my lord.
Now, if they say that the decision was that Innova is the best, best quality, it'll serve you longer, and other things to take into consideration. That is why they selected a more expensive car.
Yeah, if your lordship
can it be a consideration?
No, your lordship kindly see. There will be 2 considerations which will be falling. Kindly see this aspect, my lord. Kindly see the recommendation itself in second paragraph.
Letter you have in your
hand. And just, my lord, I will place that. Kindly see 41 only, my lord. The project sanction amount with administrative approval of NEC, Northeastern Council, wide letter number dated 31st March 20 is 6 crore 69 lakh rupees only, but the tender amount quoted by selected party and approved by tender committee is 11 crore 95 lakh rupees, only with a shortfall of 5 crore 25 lakh rupees. So I have the NEC is giving me approval of 6 crore 69 lakh rupees. And tender committee is saying that no, you go and get the extra amount from NEC. Tender committee is not a financial committee, my lord.
No. Whatever it is.
Tender committee has.
Okay, just I don't want to argue.
Yes, my lord.
With the councils. The only thing is that look, there's a process, right?
Yes, I have followed the process.
It should be sent to the logical end. Suppose his bids accepted also, but the other consideration was he called for negotiations?
No. Now the question which falls for your lordship's consideration is when there are 2 bids, financial bids. There are 2 financial bids. Now, in case L1 has given X amount. And L2 has given X plus 10. Now, in that process, my lord, L2 should be called for the negotiation because ultimately I have to get the the lowest price. I have to get the lowest price, and technical bids of both the bidders have been accepted, my lord. Technical bids of both the bidders have been accepted. There is no requirement. If there is a requirement to call all bidders to match L1, my lord.
That means you're sitting an appeal over the decision of tender committee.
Your lordship, now the question is, I am sitting over
with body.
So okay,
you just kindly give the court who are the people in the tender committee.
I will place all those. I will file a counter.
Yes.
I will file counter affidavit also, my lord. But kindly.
Till then, no allotment of any contract anybody.
You already allotted, my lord. They have said so.
Matter.
No, your lordship, kindly hear me. Then pass the interim order. Please hear me on this issue on interim order. What is wrong with this? I will just show, my lord.
Yes.
Just kindly see this issue because it has to be, my lord, because what if there is a collusion by tender committee with this supplier who is quoting 13 crore rupees, my lord, tender committee will become final over the government.
No.
So then tender, I am putting question to.
Your decision should be on.
And I have got a sanction amount.
Why didn't you inform him?
Now, question is, now he says he has not been informed of the decision, my lord. Now, this is the ground on which the decision has to be set aside? Because I have not informed me. I take it for example. This is the second point, my lord. First point is, kindly see, he himself said, he is having this letter and he has no information about the process, my lord. See, in writ petition, they have to come clean, my lord, and kindly see, I will kindly see, we all have to come, kindly see page 53, where what is stated at page 53?
Yes.
This is 29th April letter, what paragraph 5 says, that on the contrary, we have informed orally by sources in the department that the tender has already been awarded. Now, my office is a porous office. He has all the information. Who submitted what bid, my lord? And kindly see the evaluation of the who submitted. Kindly see. This is the evaluation of both the bid, my lord. And I will place the material, my lord. Both are meeting the requirements.
But there's certain, what do you call it, basic standards that have to be maintained.
Yes, process has to be maintained, my lord, but process at the cost of public interest cannot be sacrificed, my lord.
That's exactly the point, Milord.
And tender committee, my lord, and
that's exactly the point.
What is the proposal which gone to the government, my lord? 16 February, my lord, and then 29th March. These two orders.
Why are you going to this is the same copy, both of them?
I'm sorry, there will be probably evaluation, my lord. Evaluation of both the machine. Two copies, by mistake, two copies by the tender committee. I have a budget of 7 crore rupees. Both the machines are meeting the requirement, and the other company is giving higher price. Then I will go for the lower price, my lord.
There, my lords, they would do. It's not as simple as this.
This is as simple as this.
It is not as simple as this.
Because
the stipulations of the stipulation of the NIT, my lords, will be relevant.
16 February 2024.
1 second.
16 February, the matter was sent to government. You will be having a copy, but you file only selective documents. You file only
these
selective.
documents are not given to me.
No. This, my lord, page 41 was also not given to him. Page 41 was also not given to him.
See, we cannot go on presupposition and
yes, so I will file counter, my lord. I will file counter. I will file counter, but only thing I will file.
Until then, my lord, let's status quo.
Now, only thing I will say, my lord, your lordship may pass the order. This is a must.
File will take up on Friday.
Your lordship, because it will take time, and now I will be taking.
Why? Public interest demands that you finish.
Your lordship, this 9th March is the 9th March is the order. 9th March is the order.
If your lordships pass an interim order now,
Friday.
It affects only the private respondent.
No,
why is the state trying to espouse the cause of the private?
The public, my lord, because they will.
Private respondent is not supplying it on Friday.
I'm saying that if public interest is,
health
paramount.
Yes, my lord.
That means that file affidavit by tomorrow. We'll take it up
tomorrow. My lord, I have no difficulty. Monday, your lordship may have it. Monday, because by the time the Tura DC will be signing it. Yes. So one day will be.
Yes. Take down, heard Mr. K. Paul Learned, counsel by so-and-so for the petitioner. Mr. Learned Advocate General is present with so-and-so and accepts notice on behalf of the respondents number 1 to 5. Right, then
1 to 5.
Go to respond number 6. I said AB as also by personal service staff. Next paragraph. The grievance of the writ petitioner is that after being selected,
recommended by the tender committee.
After being selected and recommended by the tender committee for award of work for supply and installation of an MRI machine at Tura Civil Hospital.
Yes, my lord.
Hospital after qualifying both the technical and financial bids, it has come to his knowledge that a work order has been issued instead to respondent number 6, the other co-bidder.
Lowest bidder, my lord.
The co-bidder. This is co-bidder. This is his submission. This co-bidder. He therefore prays that he further submits that the entire transaction between the state respondents and the private respondent is unknown to him in spite of his efforts to obtain specific information. So he therefore prays that in the interim, that some interim protection be given so that the matter will not be rendered infructuous. Stop. Next paragraph. The Learned Advocate General in reply has submitted that the grievance of the writ petitioner is misplaced inasmuch as the respondent number 6 is the lowest bidder, and he also, having qualified a technical bid, had been invited and issued a work order for supply of the said MRI machine. So he has also has been further contended that as the matter is in public interest, no interference is called for by this court at this stage. Stop by further counsel of parties and further counsel of the parties stop. The attention of the court is it is noted. Not attention, but it is noted that as per the submission of the learned senior counsel, it is a fact that by a communication dated 2011-2023 from the Superintendent Tura Civil Hospital addressed to the Director of Health Services, MI, respondent number 3, bracket respondent number 3, the selection and recommendation of the writ petitioner for installation of said MRI had been informed. Stop. Is also stated in the letter that has been informed. Stop. Though the Learned Advocate General has produced a work order dated 9 March 2024 showing that the work since been awarded to the private respondent. Stop. At this stage, a prime facie case has been made out on behalf of the writ petitioner for some interim orders. Stop. Accordingly, it is directed that till the next date, the work order dated 9 March 2024 issued to the respondent number 6 shall be kept in abeyance, not be given effect to. Stop. Next paragraph. The Learned Advocate General to file on behalf of
only one submission, Milord.
Yes.
Only one submission. Your Lordship has passed the order directing that 9th March order to be kept in abeyance. This order has already been communicated to respondent number 6, and respondent number 6 is not even
represented.
Been heard,
no,
Milord.
Your
Lordship has power. I'm not questioning, but only thing is, Milord, that
kept in abeyance and status quo should be maintained. Stop. As the order has been passed in absence of number 6, number 6 at liberty to approach this court with a suitable application for modification, alteration, and vacation of this order. So advised.
226(3) will be available to him.
Yes. Till the and then
Milord,
after
then
the file. After the file,
till next date, Milord, what happens, Your Lordship has seen. What I will file reply, and next date there will be time for rejoinder, counter, and 10 dates will be there. I have got 10
Next
instances.
will be Friday.
Next date.
This is matter on Friday.
Friday, my friend will do it because I am going out of India for one month. My friend will do it.
We don't have summer vacations.
That is I am going for. So Monday, that's why I have to make some alternative arrangement, because Monday I am flying on 9th, Milord. That's my difficulty.
How you bring souvenirs for all your colleagues?
Actually,
personal. You're flying on 9th. You're flying on 9th. That's
because my daughter's convocation is there on 11th, so I have to go.
You can't miss that. That's more important than work, of course. On 9th you're leaving.
In 9th, I will get the reply file, And that's why
No,
Monday.
then take a date.
Monday, Your Lordship, Monday, have it by Monday because by
If they file the reply on by Sunday, my lords.
We'll file by Sunday.
No, if they have it filed by Saturday, by Monday, even my rejoinder will be
It is
ready.
made clear that if the reply is filed by Friday, rejoinder to the same to be
filed by Monday morning.
Please on board by Monday morning, and the matter be taken on the same day.
Yeah, and in the meantime, my friend can take steps to serve the respondent number 6
You'll also grant us liberty to serve Dasti as well.
Dasti.
Yes.
They have to serve.
I'm obliged.
Good.
$21.
The same second appeal.
Yes.
You do one thing, Mr. Khasi, you recast a substantive question of law. Both of you. Because this matter, this question was not there before the trial court. Correct? Very interesting point. We just decide on that point only. Will you do that for the court? Because our court is going to was going to make a question, but due to other engagements, it's, escaped my take down me. This matter had been set for hearing, and the substantial question of law that had been framed so court records have come. Where's the front question? One second. Only 130. Yes. S. Muthiang is?
Santimai.
From the appellant side?
Yes, madam.
You're the appellant?
Yes, yes.
He's the appellant?
Yes, yes.
Yes. No, Muthiang is appellant or respondent?
Santimai Muthiang is appellant.
Yes, Muthiang is the appellant and Jim Muthiang is the respondent. Okay. See, the one thing is here, Mr. Khasi, is that the question of right to inheritance is not in doubt.
My lord.
It's not in doubt. Now, inheritance, your inheritance is not in doubt. Correct? My lord. That an issue was framed also. That is not in doubt that, okay, your younger daughter by succession, by devolution, will come to you. Correct? But whether, the only question is whether, now if they are staying in the same property and don't have property anywhere else, because if you don't have property anywhere else, then whether you can be evicted from the ancestral house. That's what he's saying. Correct? Because that issue was not settled by the lower courts. Because only the thing is that whether you were entitled to decree of eviction. That was held affirmative. That yes, you were entitled to a decree for eviction because by devolution you are the successor in interest and, you know, of the property. Now they brought up a new point saying that whether being elder sister of whatever predecessor interest of your predecessor interest, staying that property, whether they can be evicted from that ancestral house.
She's my niece, my lord.
Your niece, whatever, yes. Whether your niece can be evicted from that house because she derives interest from her aunt or from your mother, who's your sister, correct?
My lord.
That's the thing. Because she stepped into the shoes of her sister and she's still staying in that house. Are you still staying in that house? No.
No, Your Lordship, no.
Then there's no need for such a case of law. The thing that you don't have any other place to stay. Suppose you're staying in that house and the youngest daughter's got a decree for eviction, correct, against your mother or your present interest and you. Now the only other question that had been brought up is that whether a sister, you can just see a sister, can be evicted by the youngest daughter from ancestral property if she does have any other place to stay.
I don't have any other place, but because of this order of past, I have to move out, Your Lordship.
You moved out?
Yes. Now I'm living in rent house, Your Lordship.
So you understand the question?
Regarding with that, I have no instruction.
No, sorry about that. That's the question. That is a question which we will answer. No? Whether there's success and interest, you are the person who succeeded the property.
My lord.
Now decree is in your favor.
My lord.
We're not going to overturn that.
My lord.
Because the concurrent findings. What do you on that question?
But the land is too small, my lord, to divide.
No concurrent division. Maybe she stays during her lifetime only and leaves. But you're the niece, that's the only thing. You're the niece. He's the niece and you're the auntie.
Both now are between niece, Your Lordship.
Now between the
two nieces.
But I'm the daughter from the.
No, you're a daughter of the youngest. You're the youngest daughter of the. Actually, even then, because why it goes back, because the concept of inheritance was not there. She is a custodian. The youngest daughter is a custodian of your ancestral property, and if any other clan member or family member doesn't have a place to stay, as per customary law, it's her duty to give them some shelter. That is the only question that is interesting here. That is what. Whether, as per customary law, even though you entitle a decree of eviction, even though you're the successor and interests of your, forebears, whether if this person who is your cousin, coming from the same grandmother, doesn't have any place to stay, whether it's your duty to give him shelter or something. That's why this court not to frame a question such a way, but due to, anyway, court will frame it. Yes.
Right.
Some other day. When? Very interesting point. Can you bring some authorities, principles of Khazin law?
I will try, Your Lordship. I'll try to get it.
Okay. This is after 2 weeks. We'll frame that substantial question out.
23.
Highly applicable.
Yes, Mr. P.T. Sangma.
This is the petition for payment of land compensation, where the government has acquired, the respondent have acquired my land. Now they are saying that I have constructed some additional after the notification, but on
record. Yes. Where's the respondent?
My senior is in lower court.
Who's the senior?
Sadabnat for respondent number 6.
Never made a submission in lower court. There can be no, in the state, the highest court is High Court. First priorities, remember that as a junior, never make mentions in lower court. You can see some personal difficulty. Yes, let's after 1 week. Yes.
Lordship.
2 weeks, okay.
Yes.
Due to unavailability of Mr. Debnard, yes.
28.
Much less, Lordship.
Your Lordship, the senior counsel, he's on sanction leave, Your Lordship, for his medical
He's gone for treatment. Yes.
Your Lordship, may I have it after 4
1
weeks?
month, yes. After 6 weeks.
After 6, grateful.
Highly obliged.
As this arguing senior counsel is under treatment.
32. 32.
Yes, Mr. Hassan.
May I please, Your Lordship? Lordship, our prayer is very limited, Lordship, in this writ petition, Lordship. We are seeking only the liability certificate, my Lord. What is the amount, pensionary benefit, retirement benefit lying in the office of the respondent. Though they have filed a counter affidavit, they are stating, Lordship, at para 13 of their counter affidavit, at page 13, para 8, my Lord. May I read, my Lord? With regard to the statement and averment made in para 5 of the writ petition, the deponent states that the late Constable Biren Chandra Datta expired on 25/8/2001. The family pension case is required to be settled immediately from the date of death of deceased constable, and his pension case is also required to be revised 2 times, that is as per 6th CPC and 7th CPC. Besides, family pension is also claimed by 2 wives of late Constable Biren Chandra Datta. Therefore, keeping in view of the above facts, it is not possible to intimate the amount pension due to the petitioner till finalization of her pension case. So, my Lord, that cannot be the ground, my Lord. We are not. We are not.
Yes, Mr. Dr. Mosika.
But it appears that it requires a lot of calculation, my Lord.
That's why he's not giving in.
But they have to obtain succession certificate, my Lord.
My Lord, there is the.
They don't know how much amounts are there.
How will
For
apply
pension,
for succession?
what I understand, my Lord, for pension,
You don't need to give the amount.
we don't need to give the amount. Only for the bank deposits and other things we would give.
My Lord, in case of, if we go for succession, for applying succession certificate,
stamp duty.
at least some amount we have to show. At least that is the
for
time and again we have read, my Lord, we have write application. They have given the same reply. File succession certificate, will release the. But how will go for succession, my Lord? At least some amount. What is the amount?
He died 2001.
Yes, my Lord.
Till now, pensions have been paid.
We filed
dispute in two wives, my Lord.
Well, we filed representation in 2003, and after long 15 years back, the respondent for number 5 had written a letter stating that there is a claim and counter claim. So thereafter, we filed an application.
Other person representing you made the party second wife.
No, my Lord.
Why?
The other case is pending as per the counter affidavit filed by the respondent office. Other case is other wife is filed a case before the Calcutta High Court, Honorable Calcutta High Court. As per my instruction, the notice is not yet to issued in that writ petition. As per my instruction, my Lord. My Lord,
why Calcutta High Court?
The other wife is from West Bengal. The reason why. So I am.
Where is that? Where is that information?
My Lord, in the counter affidavit, my Lord. My Lord, at page 9, my Lord.
Even your person staying in West Bengal.
No, I am from Bagmara, my Lord.
Oh, Bagmara,
my Lord. Southwest Garo Hills, my Lord. My contention only, my Lord, will ready to go to the succession court, my Lord, competent court. At least what is the amount lying in the respondent office? Let us at least issue an order, my Lord. What is the pensionary amount?
Kalpana Datta is the third wife.
My Lord, there is claim and counter claim, my Lord.
You're the first wife.
My Lord, yes, my Lord.
And where's the second wife disappeared?
My Lord, second wife, as per my instruction, is like I have no idea, my Lord, with regard to second wife.
No, but not her second wife might come forward also.
Maybe, my Lord. The Kalpana, my Lord, as per the counter affidavit, Srimati Kalpana Datta, she is the third wife, my Lord. So, which is why, my Lord, succession certificate is very much needed, my Lord. So, if we go for succession, so, my Lord, at least we need the amount, my Lord. Direction may be issued to the respondent, my Lord, to issue the amount, at least the liability certificate.
Issue the amount was there.
But we are not.
Amount.
We are not. Whether they can calculate the amount.
Mr. S.K. Hassan.
But they should include the other wife. At least they know that who is the wife.
The only short question is the only prayer that he has at the stage is for information about the deaths and security, about the
retirement benefits.
Retirement benefits
lying in the respondent office.
Lying with the respondents.
Number 5.
Number 5. Stop. He submits that this is in view of the fact that to obtain succession certificate, some amount has to be shown in the application. Next by Dr. Mbozika to obtain instructions on the submission. Just after?
Sometime, 3 weeks.
Just after 3 weeks, okay, fine.
And in the meantime, this would impede the other way, my lord.
My lord, no necessary, my
Let us
lord.
see his
We
file
are
in
not
Calcutta, my
seeking.
lord.
We are not seeking any direction,
let,
my lord.
Let them. You give that amount. Let them go and file.
My
and
lord,
let
yes,
them
my
fight
lord.
another 10 years.
In that succession, we need to make parties to them. Here, my lord, we
If
are not
in
seeking
Mara,
for
you'll
any
get
direction.
ex parte one, then you'll come presented. Then again there'll be a problem. Then
We are
she'll
not-
file in West Bengal and get an ex parte one
She's
against
going to
you.
raise the second wave, my lord.
My lord,
Yes, the second wave will come to the picture and get
My lord, that is
already
the
got a
latter
succession
part, my lord.
before you also.
My lord, that is latter part, my lord. We are not seeking here for direction. Any. Highly obliged, my lord.
Rishi, I think this is transfer.
Yes, my lord, 33 to 38 and 11. And I've circulated these.
The points of reference. Done?
Yes, yes, my lord.
Yes.
I've already filed.
Let us see.
Yes.
Yes. Let's see what are there.
This who's
From my side, I person free.
I have already.
Give them a copy.
I have already given, but my friend has not given me. I was sitting whole. I was waiting for a copy. I have given in advance to my friend.
You give back his copy.
Yeah. Lord.
Pursuant to order dated 22/4/2024, the parties, Senate Council, on behalf of all the parties, on behalf of the parties, have submitted suggested terms of reference for adjudication of the matter. The same taken on board to be examined. Further suggestions are invited.
Yes.
You know, depending on you, just examine each other's suggestions. Yes. Just after, or you won't be here for 4 weeks. Yes. I'm not sure.
Connected.
Yes. That is our patch, huh? Yeah. Thank you.
Put it in. I need this copy.
Yes.